My lord, I have an urgent matter, my lord, which was listed before court number 14. Justice Mitali Choudhury, my lord. But as she was not sitting, my lord,
What matter?
for admission, my lord, appeal. Because the period is, actually session court granted them bail. That period is over. Due to some mistake of the session court, my lord, we could not move the petition earlier, my lord. Appeal. So we filed and period is already over, my lord. That's why the urgency.
Okay.
Today, my lord,
They in the second half.
2 p.m., my lord.
Okay, at 2 p.m.
No. Immediately after the
Yes. Yes.
Of court mode may be permitted to mention a matter that is in court mode 14. Item 23, madam. Item 23.
What is the matter?
23. Madam, it is a consideration of delay petition is pending, madam. I pray that may come over second of September.
No, if it is not urgent, need not to mention.
But that is it. The delay matter is pending for some time. Madam. Court is
No,
not-
as per the notification, only urgent matters are
Yeah.
to be listed.
Madam,
I don't see any
My-
urgency in this delay
from my
condemnation
point of view, is
petition.
that delay.
No, you mention it before the court when it is listed. It is not urgent.
Madam. So can it be fixed on second? I don't, that is up to your lordship, madam.
Okay. Okay, on second.
On second, madam. I can.
Before the said court. Oh, yes.
Not today, madam. Not today. Because I am the respondent, madam. The other side is petitioner, madam. They are not there. So it's not possible today, madam.
No, you have informed the petitioner regarding the,
But I'll do that. I'll do that.
no,
Because it is not.
no,
Since
you
madam,
mention
since-
it.
Since
It is not
today,
urgent. It is not urgent.
Madam.
It is not urgent. Let it come
I'll-
up in its
Yeah. I'll do that,
normal
madam.
course.
The only problem is that, madam, since it is not fixed today. Here, madam, if it is posted to second, I'll inform them. That's not fair.
No, but the record is not before me.
It's not before you, Lord. But the notice says that it can be mentioned.
Notice says that only urgent matters are to be mentioned.
Only to be taken by your lordship,
Yes, if there is urgency.
that is only to be taken by your lordship.
You have not satisfied me on the question of urgency.
Okay.
Therefore, I am not
no.
allowing. You mention it before regular court,
Not today,
not today.
not today. Cannot be put. Because the other side, I have to inform them, they have to come, etc.
Yes,
They are-
even before mentioning, you have to inform the other side. So I am not allowing your
No,
prayer.
no.
Yes,
urgent matter in state court number 14, item number 8. In that case, against the conviction order, you also have filed. 1 month.
what is the urgency?
Urgency 1 month time is granted for filing appeal, the revision or appeal before the High Court. Today is the last date.
Okay,
Item number 8, your
second half.
May it please the page, no?
May it please the last one.
Lordship, I beg to mention item number 50, Lordship. In this matter was listed on 20th
Item number 15 of which court?
of this honorable
Yes,
supplementary bail hearing, Lordship. On 20th, TCR was there, Lordship, with the reports, Lordship. But today I have checked, no TCR is there, Lordship. TCR is received on 5/8, Lordship, from the court.
what is your submission?
Lordship may be called for, TCR may be called for, in the official.
Okay,
of last.
verify.
In item number 4, lordships, your daily brief lordship. We filed an additional affidavit that may be tagged the record.
Yes, call for the additional affidavit. Item number 4.
May I please, your lordship? My lord, normally I do not pray this type of prayer, my lord. Pray for urgent unlisted motion, but considering the other courts, my lord, now I have pray for tomorrow listing, my lord. what happened if Dr. BDS Malad has been arrested, Malad. This honorable court, Malad, on the very motion day released him bail. Now the other police registered a case by other doctor, Malad, regarding falsehood.
When
And,
have you filed?
Malad, today, Malad. That's I pray, Malad,
There,
tomorrow.
it will come,
Malad, I am going to the registry, Malad, unless your lordship permission is not okay, they will not.
they
That
will,
is-
it will come up. It will be listed within 2 days automatically.
Malad, very urgent, Malad, because of the already arrested release bail, or when he approached that court as per direction of this honorable court, that officer of the other police station, Malad, there is a serious apprehension, Malad. He will be again put behind the bar. It is absolutely because of the Malad professional liability
Anticipated bail.
and discipline.
Okay.
Already I have arrested. I
Oh,
released
okay, okay, tomorrow.
Beg to mention for listing of a transfer petition criminal lodge on Friday lodge.
When have you filed?
Spending matter lodge. Last listed on 17 February 24. It's a DV matter lodge, which is the proceedings are already going on in judicial magistrate first class at Phaggo.
Okay, on Friday.
On Friday lodge.
Meet with the lordship. I beg to mention item number 1 of port number 14 lordship. It's a bail application and a petitioner lordship in this case is behind the wall for last 62 days lordship. The urgency is there only.
Bail application.
Bail application. CD, charge sheet is not filed yet. The 62 days is behind the wall.
In the second half.
Lordship, must obey.
May I please, Madam?
May I please, Lord? I beg to mention court number 14, item number 26, Lordship. Matter may kindly listed on 29 August, Lord.
No, it will be listed
Listing for
for fixing dates.
date, Lordship.
That is no urgency. The dates will be fixed by registry automatically.
Obliged.
May I please, Madam? My lord, I paid for listing of one WPC criminal for motion, my lord. My lord, I have filed this writ petition for crossing, my lord. What happened this case?
When have you filed?
Today, my lord. My lord,
Wait
this-
for its,
My lord,
wait for it to come in its
my lord,
due course.
there is some urgency. my
What
lord.
urgency?
My lord, what happened, the petitioner before lordship is a secretary general of the bar association, my lord. One person has appeared without any license, anything, he has lodged the FIR. Against that, my lord, to counter that FIR, another FIR lodged by that person by my incorporating the sections under the SC/ST Act, my lord. And since there is anticipatory bar, my lord, under the SC/ST Act, my lord, therefore we have preferred this writ petition criminal. He is the secretary general of the bar association, and now police is, my lord.
Which bar association?
Tinsukia Bar Association.
Tomorrow.
Obliged.
Please, your lordship. Lordship, I filed the bail application, lordship. It is rejected by Justice, Honorable Justice Mittal Thakuria, lordship. So lordship.
It will go before the same bench.
Same bench, lordship, can it be on Thursday, lordship?
When have you filed?
That last week, lordship.
Okay.
Obliged, lordship.
May I please, your lordship? Lordship, I beg to mention, beg for listing of a criminal revision petition tomorrow, your lordship. Lordship, we have filed it against the order of family court, your lordship. Family court without considering my amount of
When
salary.
have you filed?
Lordship, today. I
Wait for your turn. It will be listed within 2 days. If it does not get listed in due course, then only you have to mention.
There is again fixed.
Why you were waiting till today? You have to wait till the matter is listed in its due course. If it does not get listed within 2 days, then only you mention. Yes,
Make the but I have to mention for listing criminal appealment. Regarding the bail matter, it may become hands of Friday matter.
when have you filed?
File matter 2023 matter. Last posted 24/7/2025 matter. On the
May pray before registry.
registry.
Yes,
Sure, bail application filed last week.
fresh matter.
Yes, madam. Right.
Tomorrow.
It is your lordship. My lord, my humble praise for listing of a criminal revision petition for others column lordship. Any convenient date lordship. Next week.
What was the last order?
It was notice was issued, your lordship. We took steps on private respondents. It has been served. We also took justice service and file affidavit, lordship. So it can be disposed of, your lordship.
Next week,
Monday, lordship.
next week, Monday.
Deeply obliged.
May I please, your lordship, I beg to mention item number 23. Lordship, allow us further time to file our objection.
Have you informed the petitioner?
Lordship.
You have informed?
Yes.
Heard Miss M. Deka, Learned Counsel for Customs Department, Learned Counsel for NCB, who seeks how much time?
7 days time, 1 week time.
A week's time to file written objection against the prayer for bail. She submits that she has informed the learned counsel for the petitioner regarding her prayer for seeking time. Hence, the prayer is allowed. Let this matter be listed in the next week on a date to be fixed by registry.
LC also not received.
It appears from record that the trial court records, which was requisition in this case, has not been received. Issue reminder for the same.
Highly obliged.
Yeah, please. Lordship, I beg to mention for listing a criminal appeal with ILO. Lordship, it is a fresh case, Lordship. Lordship,
When have you filed?
18-8.
Malikiman cases. Suggested it. 3rd September. 3rd September.
Alright.
May I please, your lordship. The item number 55 of today's list, your lordship. It is wrongly come in bail hearing column. It ought to have come, your lordship, motion column. Item number 55. Supplementary.
It should, okay, we'll take it up. Item number 55 motion, maybe motion of Mati. Will,
Call for on, I don't know, I think.
we will check. If he is making wrong submission, we will deal it with. the appropriate-
Supposed to come today in motion column, it is inadvertent mistake on my part, maybe. I have submitted amended cost title page, but that was not tagged on last occasion.
Your
lordship.
submission is that it should have come in motion column.
Yes, your lordship, because
We'll take it up after motion, last motion item.
oblige your lordship.
May I please, Lordship? I beg to mention item number 53 from supplementary list. This item may be taken at 2 PM. Upgradation.
No. No, wait for your turn.
May it please your lordship. Lordship, I beg to mention item number 5 in code number 14, your lordship. It is a fresh transfer petition. Lordship, there is some urgency in the matter, lordship.
What is the urgency?
Lordship, the matter is fixed in the trial court on 4th of September. So lordship, any date before that would be.
What's day after tomorrow?
Deeply obliged, lordship. Yeah, lordship.
Lordship, I beg to mention for listing of bail application,
When have you filed?
22/8.
22? Why it has not been listed? Tomorrow.
Obliged.
May I please, your lordship? I beg to mention item number 40.
Of these courts.
Yes. This is a hearing matter, old matter, we are to take a file, one permission. And we have lost this LCR matter, so we may be allowed to take a copy of this with evidences. So I am to reconstruct my file. That is the problem here. It's a 13 matter. And
We'll pass the order if the matter reaches and when the matter is called for. When the matter is called in its due course, we will pass orders. You wait for your turn.
obliged.
Please, your lordship, I beg to mention a listing of an bail application, your lordship, under 483 of BNSS.
When have you filed?
Today, your lordship, kindly it may be listed tomorrow.
Wait for your turn. No, all bail applications are urgent. You have to wait for the, if it does not get listed in its due course, only then mention has to be made.
May I please, your lordship? Lordship, with regard to item number 43 and 44,
of this court.
Yes, Lordship, for reason 44, Lordship, we are going to file an IA for infliction of substitution because my lord deadline has been done. So his wife wants to substitute him, my lord.
Wait till the matter is called. Wait for your turn.
Obliged.
May I please, Lordship, I beg to mention item number 24, Lordship. Instruction is not received, Lordship.
You have informed
Lordship,
the,
I'm for the petitioner, short date may be given next week, Lordship.
heard Mr. N. Kakoti,
N.
Miss M. Kakoti,
And
N. Kakoti, learned counsel for the Customs Department, who seeks some time for taking necessary instructions in this matter. Mr. L. R. Majumdar, learned counsel for the petitioner, does not oppose the prayer. Hence, the prayer is allowed. How much time?
1 week, Lordship.
Next Monday, Lordship.
Let this matter be listed next Monday, 1st of September.
Obliged, Lordship. May I please, Lordship, I would like to back for a listing of a criminal appeal, Lordship, in the order, for orders, Lordship.
Why?
Lordship, because already in the earlier date, notice has been issued. So this matter may be listed for order.
Next week.
Date may be fixed.
3rd of September.
I think one.
May it please the Lordship. Lordship has earlier rejected this application.
We'll call for the case diary.
He paid his package.
I don't remember anything. When can you give a short date?
Thursday.
Heard Miss T. Som, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. Call for the case diary. Fix this matter on. Heard
Thursday.
28.
on 28 August.
May I please? My lord, this is second bail application, my lord. My lord, today is the 88 days. Now. Earlier rejected. High order date
88.
88 days.
88 days.
My lord.
You
They
take instructions. We are fixing it.
Perhaps not filed, day after tomorrow, madam.
We are fixing it day after tomorrow. Heard Mr. A. Paramanik, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor, who seeks 2 days' time to get information from the investigating officer as regards the status of investigation in this case. The prayer is allowed. Let this case be listed on 28th August.
Welcome.
He also same, my lord. This
Ma'am,
must
please,
be-
your lordship. Today is 82 days, my lord, earlier rejected by this honorable court. Offense, my lord, under section 316 and 5. I'm a bank employee, my lord. Allegation is that in an account of a customer, my lord, a huge
This-
amount of money was.
same, my lord.
In the same
Same.
same
Must also
case.
38 days.
Same.
Earlier case, Hassan Badri and
But my lord, today is 82 days, my lord.
But already city call in 28.
heard Mr.
20.
R. Sharma, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. Call for the case record, case diary. List this matter on 28th. Day after tomorrow. 28th.
Obliged, my.
4 is, my lord, same with
Same with, on
Item
28th,
one,
my lord, of course, I will be out on 28th, it may fix. Same as, item
item
number one.
number 1, my lord.
Heard Mr. R.P. Sharma, learned senior counsel assisted by Ms. T. Som, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, call for the case diary. List this matter on 28th.
All right.
May it please your lordship, I may submit that item number 13 is also arising out of from the same police station, and the petitioner therein is none other than my wife. With your lordship's kind
Item number
13. With your lordship's kind permission, I may be allowed to address both the matters together.
yes,
Earlier rejection.
we have to peruse the case diary.
Item 12 also similar.
My lordship, this is a third bail application before filed before this honorable court. On the earlier two occasions, your
Okay,
lordship was
Mr. Sharma, when can you bring the case diary?
Lordship, regarding this case, Lordship, just a short submission, Lordship. The thing is, Lordship, earlier it was rejected, Lordship, considering the severity of the offense and also the Lordship punishment it entails, Lordship, and the need of custodial interrogation was also stressed before by your Lordship. Now, Lordship, this is the third bail application, Lordship, and the statutory period is 90 days, a long way to go. So my submission is, Lordship, they have to show, Lordship, the change of circumstances for filing repeated bail application, Lordship. Without that, Lordship, this is not maintainable, as has been held by the Supreme Court. Lordship, some going by the same grounds taken in the successive bail application is not maintainable, Lordship. That is my humble submission.
No,
They-
but lapse of time in bail applications,
Only
lapse
regarding that, only regarding.
of time,
Yes, lapse of
investigation might have progressed.
that in my respectful submission, Lordship has already taken care of it, Lordship, considering the severity of the offense and the punishment it entails, Lordship was.
How many days you are behind the bars?
lordship, till today, it's 40 days, lordship.
Only 40 days, Lordship. This is
And
the
also,
third
lordship,
bail application.
there is also a medical condition, lordship. The wife of the petitioner is had a miscarriage and was undergoing treatment, your lordship.
That also has been
before
taken care
arrest,
of, by
lordship.
But that cannot be, Lordship. It has,
Lordship,
there
till
has to be
today-
some change in circumstances.
Lordship, till today, the petitioner has almost spent 40 days, lordship. And it was,
That
the
cannot be
duration is
allowed.
almost.
What is your ground for?
Lordship, the fresh ground urged today is the length of the detention and medical ground, lordship.
That cannot be wrong. We can do this case today itself, Lordship. They have to show, Lordship, this change of
Lordship,
circumstances.
the petitioner already spent 40 days, lordship. Lordship,
Call for the case diary.
lordship, I kindly pray your, before honorable court, honorable court to kindly, up to date, the case diary.
You take time, no urgency.
No issue on that. Lordship.
When can you produce the case?
As your Lordship directs, we have no issue, Lordship.
After a week. Case diary. 9th of September.
Oblige,
So Lordship will kindly keep the,
Heard Mr. P. Talukdar, learned counsel for the petitioner. In item number 13 of similar order. Learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Learned counsel for the petitioner submits that this is for the third occasion the petitioner is approaching this court seeking bail. On the other hand, learned additional public prosecutor submits that on earlier two occasions, the prayer for bail of the petitioner was rejected after perusal of the case diary. And the petitioner has not been able to show any new ground for approaching this court, apart from mere lapse of time. Stop. Considering the submissions made by learned counsel for both sides, perusal of the case diary is felt necessary for consideration of this bail application. Hence, call for the case diary. Fix this matter on 9th of September.
12 is also similar.
12, 12, let the council may be different. 13 and 5 order account.
Lordship.
Your Lordship, 483 application, Your Lordship. Offense number 21B, 29 NDPS. Your Lordship. Maybe around 33 days, Your Lordship, judicial custody.
What is the offense?
21B,
21B,
How many days?
33 days as of.
Case diary.
8 or 9.
Heard Mr. U.K. Burman, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. Call for the case diary. let this matter be listed on 10th
Tenth, yes, sir.
of September.
Right.
May I please your lordship? Right at the very outset, I take lordship page 29. Where your lordship has disposed the matter with the direction to approach the court below as case the charge sheeted manner. It was an intermediate quantity manner, 6 grams of suspected heroin mix. So, my lord, accordingly, I applied before the special judge.
What is the
Silchar,
quantity?
6 grams.
6.
My lord, on 11/8/25, my bail payer rejected on the ground that it will go wrong message in the society. Hence, I am again before your lord. I pray that I will be granted bail, my lord, under any condition. 90 days behind the bar,
How many days?
90 days,
19.
90
90.
from 29/5.
Where is the rejection order?
Rejection order, page 27.
What is the ground for the?
Oh, wrong message will go to the society, my lord, if bail is granted. I have last line, my lord. You want wrong, sir? You want wrong, eh?
6 point.
No, no, 62.06 grams. 62.06 grams.
It is not 6. It is 62.
62.06.
It is,
Page 28, 62.
yes, Mr. Parashar. What is to be done?
Rejected that. I have approached court. Honorable court directed me to approach court below. I have approached. I am the driver. The main truck owner is my lord, somebody else, my lord. His whereabouts is also done not inquired in reflecting this charge sheet. 29/5, no?
When were you arrested?
I was arrested 29/5.
29.
29/5, yes.
Heard Mr. S. P. Vishwas, learned counsel for the petitioner. Also heard Mr. K. K. Parashar, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Ghulam Wazid Borbhuya, who has been detained behind the bars since 29/5/2025. Within bracket, how many days you have calculated?
90 days. 90 days.
For last 90 days in connection with NDPS case number 68/2025 under section 21B of NDPS Act, pending before the Court of London. Special Judge Special Judge Kachar Silchar. Stop. Learned. The petitioner is facing a trial before the Court of Learned Special Judge Kachar under section 21B of NDPS Act for on accusation of possessing 62.06
62.06.
grams of heroin. Learned counsel for the petitioner has submitted that the petitioner has been detained behind the bars for last 90 days and there is no embargo in granting bail to the petitioner. He also submits that since the charge sheet has already been laid, there is no necessity of detaining the petitioner behind the bars as he is ready to face the trial. However, merely on the ground of seriousness of the offense, as well as incriminating materials against the petitioner, the prayer for bail of the petitioner was rejected by the learned Special Judge Kachar. Stop. Learned counsel for the petitioner has submitted that the petitioner is a, where is your residence?
Driver, murder. I'm Manipur, murder.
Then what is the assurance that
Oh, I'm not Manipur. I'm from Kachar itself. Tonight. Assurance, murder, any condition, murder, your lordship.
is a permanent resident of
Sonai, under Kachar district.
Ramnagar Part 4 under Sonai Police Station in Kachar district, and he is ready to cooperate in trial, and therefore he may be allowed to go on bail. On the other hand, you are opposing?
Okay.
On the other hand, learned additional public prosecutor opposed the grant of bail to the petitioner on the ground that the trial court has rightly rejected the prayer for bail, considering the seriousness of the offense involved in this case. I have considered the submissions made by learned counsel for both sides. The quantity of contraband seized in this case is of intermediate quantity, therefore, the embargo of section 37 of the NDPS Act is not applicable. Stop. Moreover, the petitioner has been detained behind the bars for last 90 days and he is ready to face trial and cooperate in it. Therefore, this court is of considered opinion that his custodial detention may not be necessary for fair completion of the trial if he cooperates in it. Stop. Considering the above facts, the above named petitioner is allowed to go on bail of rupees 50,000 with one surety of like amount, subject to the following condition, trial conditions. This bail application is accordingly disposed of. Request that heard Mr. N.J. Dattar, learned counsel for the petitioner. Also heard Mr. A.K. Parashar, learned additional public prosecutor. Call for the case then. When? 9th. Release this matter on 9th of September.
Like here, my lord, it is a charge sheeted case, my lord. Lordship may call for the, my lord, scanned copy, my lord,
It's an NDPS matter.
NDPS.
Heard Mr. N.J. Dattar, learned counsel for the petitioner. Also heard Ms. N. Kakoti, learned counsel for NCB. Let the scanned copy of the trial court records along with the scanned copy of the connected case diary be called for from the trial court. The registry to take steps for requisitioning the scanned copies. Let this matter be listed on 16/9.
I'm obliged, lord. Wait, please, lord.
This is a regular bail application in connection with Gusaigaon PS case number 115 of 2025, your lordship.
Fix it. Yes, we are calling for the case diary. Heard, Mr. What is your name?
Mohammed A. Rahman, your lordship.
Muhammad A. Rahman. Learned counsel for the petitioner. Also heard Mr. K.K. Parashar. Call for the case diary. Let this matter be listed on 10th of September.
Highly honored.
Please, your lordship. Also, petitioner before lordship have been behind the bar for the last 61 days and is suffering from 100% permanent disability. Hearing, suffering from hearing impairment. This is saturated case, my lord. Yes. Saturated frame under section 65, within bracket 2 of BNS release section 10 of POCSO Act. Already informed and victim have been examined. They were no way implicated the petitioner regarding the involvement of this case.
Will issue notice to the
Notice
informant.
and can copy my vehicle.
Heard Mr.
Yes, go ahead.
S. Gogoi, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. Issue notice to the respondent number 2, as well as call for the scanned copy of the trial court records. Stop. The petitioner shall take steps for issuance of notice upon respondent number 2 in pursuant to the prevailing notification of the registry in this regard. The registry to take steps for requisitioning the scanned copy of the trial court records. Let this matter be listed. Listed on 17/9. 10/9. 10th of
The second bill application, my lord, CD may be called for, my lord.
That Sonapur case already fixed on 9/9, my lord. Other two cases are fixed on 9.
Yes. What is your name?
H. Rahman, lordship.
H. Rahman. Call for the case diary, 6/9/9. A.K. Parashar Nam.
Online, lordship.
May please, your lordship. We have an application under 483 BNSS, your lordship. Petitioner has been arrested under section 21C of the NDPS Act. And your lord, he was arrested on 13/12/2024. At this stage, your lord, you may call for this.
And Mr. Y.S. Mannan. Also heard Mr. K.K. Also heard Ms. M. Deka. Learned counsel for DRI. Let the scanned copy of the trial court records be called for. Let this case be listed on 16/9.
Obliged.
May I please, your lordship, it's a charge sheeted matter, my lord. Can copy of the TCR may be called for, my lord.
Heard Mr.
A. Basmati, my lord.
A. Basumatari, learned counsel for the petitioner. Also heard Ms. M. Deka, learned counsel for NCB. Call for the scanned copy of the trial court records. Please this matter on 16/9.
Highly obliged.
Obliged.
Make this lordship. My lord, an application under section 483 lordship. FIR case 80 lordship type copy. My lord, in connection with this case, another 3 accused person already granted bail by a High Court lordship. I have carried for this order.
Since when you are behind the bars?
1/8/2025 lordship. After 25 days.
When can you bring the case diary?
Jalukbari, my lord.
Lordship. On 22/8/2025, last Thursday, lordship, the bail was granted. Can you see the pair of High Court?
Who are you
I'm the driver and handyman of the vehicle.
and who were the petitioner who were granted bail?
They are also the driver and handyman.
How many drivers?
2-3 vehicles is there in lordship.
Bolero pickup.
Yes, your lordship.
We are fixing a short date for case diary.
Full. Fourth.
Fourth.
Next week.
Okay. Heard Mr.
Yes, Rahman.
S. Hawk,
Yes, Rahman.
S. Rahman, learned counsel for the petitioner. Also heard Mr. K. K. Parashar, learned additional public prosecutor. All for the case diary. Let this matter be listed on 4th of September.
17.
May I please do that? Firstly, this bail application is in connection with Bongaigaon PS case number 173 of 2025 under section 64 2M CPC 1.
64,
Yes.
we are calling for the case diary and you take steps for issuance of notice.
You didn't know? Yes. You want to know, sir?
Heard Mr. S. Das, learned counsel for the petitioner. Also heard Mr. K. K. Parashar, learned additional public prosecutor. Call for the case diary and issue notice to respondent number 2. The petitioner shall take steps for issuance of notice upon respondent number 2 in pursuant to the prevailing notification of the registry in this regard. Stop. In this regard, within 3 days from the date of this order, returnable on
9th.
9th, 9th of September. List accordingly.
Much obliged.
Item 18.
Mr. Lordship 438 bail application. Accused was arrested on 17/7/2025, days 40 days. But there is no any recovered from the possession of the accused person. Only on the statement of co-accused Sanjay Gogoi, the accused was arrested by the police.
Heard Mr. G. Fukon, learned counsel for the petitioner. Also heard Mr. K. K. Parashar, learned additional public prosecutor. Call for the case diary.
11th.
Let this
Nine.
matter be listed on 9th of September.
Item 46 from supplementary.
Please, your lordship, correct the application, lordship. Petitioner was arrested on lordship 16/12/2020, lordship. So he is inside the jail for about 4 years, 8 months, 10 days. It is similar with item number 23, lordship. In item number 23, lordship already called for the case.
When?
Next week, lordship.
What is the date?
Next week, any date, lordship, it's from Kamrup Metro.
Heard Miss S. K. Nargis, learned counsel for the petitioner. Also heard Miss M. Deka, learned counsel for NCB. Let the scanned copy of the trial court records be called for. List this matter on 5th of.
Along with BA number 213420.
On 5th of so and so. List this matter along with bail application number
2134.
2134/2020.
Item 47.
May I please, your lordship? No, this petitioners was arrested, my lord, on 28/8/25, my lord, the two petitioners before your lordship. My lord, I'm not going into the details of the merits, just in nutshell, my lord, because I am on the legal issues in this case right now. My lord, this petitioner, they have been engaged by the informants company. That lordship will find the FIR at page 18 for supply of diesel to their premises, my lord, the construction premises. And for that purpose, my lord, they have issued the petroleum card to me. And by sweeping that petroleum card, I have to purchase those diesel from any of the pump, my lord, and I have to supply it to their premises, my lord. And they will receive it, and the money will be through their transaction entirely through their own petroleum card. And subsequently in the FIR, they have allegation is that their own person in the premises, he has did some mischief And accordingly, there is some misappropriation of the amount regarding the supply of the petroleum. And their only suspicion against me that I have, through my mobile application, I have paid some of the amount to the person, their own person, who has misappropriated the money, for the supply of the diesel. They are the nutshell of that, he is absconding, so they are, now at this stage, the main legal issue involved is the issuance of notice 35 as per the requirement of the until judgment, And Lordship knows it very well, probably hundreds, thousands of the judgment Lord has given by in the meantime, that there are twofold requirement in the until case. First of all, the notice is mandatory prior to the arrest. If the offence is alleged is 7 years, within the ambit of 7 years. Here, and only not that, and he has to give, the IO has to give the reason for not giving the notice. That's more important. Ground is not important, hundreds of grounds can be, but the reasons are more important, under which he can satisfy the court that because of these reasons and the existence of these reasons, and which cannot be superficial and which has to be based on fact, and because grounds can be given by anybody, but the reasons are more important. Why, under which belief he has not given, that reasons is very important. He has not given any reasons. Simply one line is there, why he has, and his understanding of that law is also very peculiar, He has said, if I issue the notice, I cannot arrest him. That's not the law, Issuance of the notice also, thereafter interrogating, he can arrest them. There is no bar at all. He has to only give the reason for not arresting or without notice. But here, only ground is that if I issue the notice, I can't arrest them. That is the ground he has given. And the second fold important is the twin folds. The next part is we have specifically taken that ground during the production. There is no notice. Our petition has been annexed here. There is no notice under them. These are the requirement of the second important factor is that the magistrate, while going by that, he has also to give his own reasons that he is satisfied by the reasons given by the IO for forwarding him to the custody. Here, he is absolutely, in spite of the specific prayer to that effect, that is not been complied with, no whisper at all, how he is satisfied, not even mention that is, no mention of 35, Now, Lordship, kindly see the forwarding report, page 22. Here, all section is a cheating, misappropriation within the 7 years, Now, Lordship, kindly see page 25. From the bottom, second paragraph, further, page 25.
Yes.
Further, the notice under 35(3) BNSS is not complied to the accused person. So admittedly, as the accused person are found to involve in the fraud case, huge amount of money, and if the accused person released by complying the notice, they will hamper the investigation tampered with the evidence. So he is under the impression that if the notice shall, after giving the notice, if they are released on bail, they will hamper the investigation and tamper the evidence. But if where from, simply on that, there's no reason. It's just a ground that it has to be reason, The until is very specific, 27 point in the paragraph 27 in 7.2, the record of reasons in writing which led him to come to the conclusion. That's not important. But here there's no reason. His reason is simple, if I huge, and if the accused person released by complying notice. So he's under the impression that if the notices is issued, they have to release on bail. It's not that, So he has not complied with the 35. Now, Lordship, kindly see and the page 26, they have said only 47 notices, 48, 47. That's not the important at this stage, Now, Lordship, kindly see our petition that we have specifically prayed during the page 27 onwards and page 29.
Paragraph number 4.
Paragraph 4, we have quoted the relevant provisions and the requirement of the notice. Paragraph 4. Now, in spite of that, now Lordship, please come to the rejection order by the forwarding court, my lord. It starts from page 34, my lord.
Yes.
Now, 37 also says, IO in the case in connection with the noted has reference along with the forwarding arrest memo, inspection memo, notice under 4748, checklist of arrest without warrant under section 35 B of the BNSS and D. So without warrant, my lord, that's so IO so and so heard the IO, perused the CD as well as CR. Upon perusal of the material on account, finding it grounds of arrest to be satisfactory, I am of the view that the arrest of the accused person is justified. Remand of the accused into taking into the account nature of the circumstances of arrest alleged to be committed, prayer of the police remand is allowed. Accordingly, bail remand is so and so. So he's only said it that finding grounds of arrest is satisfactory. Why? That is a different issue, my lord.
This is 40.
That is 47, 48 grounds of arrest is different. But why notice was under section 35 is no whisper at all. Now, requirement of the until, my lord,
What it says?
it says the first of all, for the police, my lord, I'm just reading, my lord.
Para?
It para, my lord, 27, my lord, 7.2, my lord, internal placidit D, my lord, placitum D, my lord, 7.2. The law mandates the police officer to state the facts of and records the reasons in writing which led him to come to the conclusion covered by any of the provisions aforesaid. My lord, that from A to E of the page 84, my lord, internal.
Yes.
Paragraph 27, my lord.
Yes.
7.2. The law mandates that the police officer to state the facts and record the reasons in writing, not the grounds, which led him to come to the conclusion covered by any of the provisions aforesaid. Any of the provisions, that means, my lord, section 41 from A to E. A to E does not mean that if I issue the notice, I have to release the person. That's not the mandate. A to E is a totally different. So here, simply the grounds has been given that I have not issued the notice, because if I issue the notice, if I release the bail, on bail, they will tamper with the evidence. Not a case that if there are any flight tricks or anything required under A and E. Now, this is the second part. Now, the second part, this is more important, my lord, 8.2 in our page 85. Before a magistrate authorizes detention under 167 CRPC, he has to be satisfied that the arrest is made is legal in accordance with law and all the constitutional rights of the person arrested are satisfied. If the arrest effected by the police officer does not satisfy the requirement of section 41 of the code, magistrate is duty bound not to authorize his further retention and to release the accused. In other words, when an accused is produced before the magistrate, the police officer effecting the arrest is required to furnish the magistrate the facts and reasons and its conclusions of arrest. And the magistrate in turn, this is very important, is to satisfy that the condition precedent for the arrest under section 41 CRPC has been satisfied, and it is only thereafter he will authorize the detention of the accused. So condition precedent is that he must be satisfied that in section 41 has been complied with or non-complied with because of the reason. Here is not a whisper. Admittedly, they said they have not given the section 41.
In this A to E,
My lord.
whether the apprehension of tampering with the evidence is one.
My
one
lord,
ground.
you can see A to E, my lord. But the other part, my lord, the magistrate, here the admittedly, magistrate, they have said that they have not issued the notice. Now, it is the incumbent on the magistrate. He has to satisfy himself that yes, the reasons given by the police for not issuing the notice under section 41 is acceptable. That finding has to be there before authorization or further detention, my lord. That is the requirement of the magistrate, my lord. That cannot be bypassed, my lord, whatever may be. He has to give his own reasons. He cannot go by the whatever the police has. Anesh Kumar.
Yes. Mr. Parashar.
My lord. Regarding the notice, my lord, the IO has mentioned the reasons, my lord. It nowhere it is stated, mentioned that this is the ground. Because of the reason that he may hamper and tamper with the.
No, whether the police has option or not to issue notice in offences which are punishable under up to 7 years.
Well, then he has to give reasons.
No. He has to issue notice, and then if he requires that, if he thinks that arrest is necessary
Mandatory.
in spite of, then he has to give no reasons. My question is, before arresting, he has to give reasons, even if he has issued notice, whether he
Yes.
has an option of not issuing the notice. Yes, Mr.
Yes,
Whether that option is there.
no, my lord, he has to, my lord, in some cases, option is the notice is not mandatory. In a case of trap case, it is between the 7 years, my lord. Then no notice is required. That is a different proposition.
So option is there.
Yet an option is there in some cases. In a trap case, my lord, that option is there because there is no, if the trap will fail if the notice is issued. And in case of, my lord, this, so in some cases, notice is always not the mandatory, my lord. But my thing is that you have not issued the notice here.
No,
And-
but 35,
35, yes, ma'am. 35 otherwise, my lord, yes.
As per 35(3), my lord, the police officer in all cases where the arrest of a person is not required under subsection 1, issue notice directing the person against whom a reasonable complaint has been made or credible information has been received on a reasonable suspension exists that he has committed cognizable offense to appear him before him. So if not required, section 35(3) said if not required. Now IO has given the reason, my lord, he is required. And if notice is given, he may hamper and tamper with the investigation and tamper with the evidence, my lord. That reason has been given. In otherwise, my lord, when in those cases, my lord, where section 47 and 48 not comply, even though magistrate satisfied, and here arguments has been made that magistrate satisfaction is not mandatory, but notice has to be given.
No,
Now,
no.
in this case, 47, 48, that is.
I'm not-
complied.
No, he is not pressing.
I have stated that even though in those cases where 47, 48 not proper, but magistrate has the satisfaction, then also argument has been made that
No, that's a
compliance of
different
the-
proposition,
yes.
ma'am. But here is
Now-
the 35 notice. In case of 35 notice, my lord, the mandate is that he has to give a reasons for not giving it. And if he arrests it also, he has to give a cite the reasons for the arrest. That's
Where is that in 35?
the,
Reasons for not giving notice.
yes, directly it's not there, my lord. Directly is not there, but some cases, my lord. That's why I'm saying, supposing a trap case, there's no requirement of the giving the notices. Under section 7 of the PCA Act, man. Because the trap will fail. in similar cases of NDPS, if there is a prior intimation, my lord, from the secret information, then notices is not important. Similarly, suppose in a small quantity, possession of the small quantity for personal use, the below 7 years, trap cases. So my understanding is, my lord,
Then
all cases,
we have to peruse the case diary.
but the second part is most important, my lord.
To
The magistrate part.
what were the grounds? Magistrate has gone through the case diary.
No, he has
How?
not given any reasons, my lord. That is the requirement, my lord, that he has absolutely silent regarding the 41. He can't be, my lord. He cannot. He has to address why the 41 has to be. That is the requirement. That you kindly see 8.2. That's very important. He cannot authorize the detention. That first satisfaction I can understand. He can think about the remand, but he has to give the reason. That he cannot bypass, my lord. To authorize my detention, that is a mandatory, my lord. 8.2, my lord. Lordship kindly see.
No, he has given upon perusal of the materials on record.
Reasons, my lord. That will not sufficient, my lord. Reasons and its conclusion of for arrest. Lordship kindly see the language. Otherwise, that will be just a futile exercise, my lord. In all cases, before the 41, he has to give the reasons for 41. Here is the mandate, my lord. The 41, he has admittedly now 41 has given. He was silent regarding that the yes, 41 is not given by the police, and I am satisfied. The reason cited by the police for not giving the 41 is complied with. That is where is that, my lord. He is regarding the 47, 48, and he himself said that the arrest without for 35B, then he is absolutely silent about the 41. That is the requirement of the 8.2, my lord. Lordship kindly see 8.2 and 8.3, very important, my lord. If before magistrate authorize the detention under section 167, he has to be first satisfied that the arrest is made is legal in accordance with law in all constitutional right of the person arrested is satisfied. If the arrest effected by the police officer does not satisfy the requirement of section 41 of the code, magistrate is duty bound not to authorize his further detention and release the accused. In the other word, when an accused is produced before the magistrate, the police officer effecting the arrest is required to furnish the magistrate the facts and reasons. There is no reasons at all. This is the grounds, my submission. And in conclusion of its conclusion for arrest, and the magistrate in turn is to satisfy that the condition precedent of arrest under section 41.
No, whether this constitutes the reasons. When the magistrate says upon perusal of the case diary and case records and upon perusal of materials on record, I am of the view that arrest of the accused person is
So
justified.
now that he has to give a reason why 41 he has bypassed. That not 35, 36 I can understand, but the 41, 30 in that he has to give a reason for that. Yes, there is nothing, my lord. Simply because our plea was very specific. Now, lordship kindly see 41 CRPC has been satisfied. 41 CRPC has been satisfied. Very specific. That means what? 41 CRPC, that means the mandate of giving notice or not giving the mandate. Where is that, my lord?
41 says the grounds when he can be arrested.
Yes, but the
without warrant.
reason, that is also important, that in the reasons, the 41, not only the grounds, that has to incorporate it in the by way of reasons for not arresting or arresting, both. In case you arrest, then also you have to give reasons. If you don't arrest also after giving the notice, you have to give reasons, both. But where that 41 is not only that, my lord, 41 is the first of all, the notice. Requirement of the notice. You can arrest the person, there is no bar, as my humble submission. But in that fact, the first of all, IO had to give the reasons for not giving the reason in writing. And second part is that magistrate come to a conclusion that I am satisfied with the ground for not giving the 41 or 35 notice. That is the requirement. The magistrate, before authorizing the detention, he will record his own satisfaction, maybe in brief, but the said satisfaction must reflect from his order. That's important, my lord. That's his satisfaction, my lord. Where from? He is satisfied that the 41 has been complied, or he is satisfied the reasons given by the,
We have to peruse the case diary.
well, in the meantime, that's why I'm asking for the interim. Well, apparently that's not been followed. I'm asking for, that's why I'm not going into the merit of this case, my lord.
Zagirud, my lord,
And-
and short that we can.
When can you produce?
My lord,
Sure.
third, my
And-
lord,
Third,
next week, my lord.
third, Mr. A. M. Bora, learned counsel for, learned senior counsel assisted by Mr. A. K. Bodjo, learned counsel for the petitioner. Also heard Mr. K. K. Parashar, learned additional public prosecutor. This application under section 483 of BNSS 2023 has been filed by the petitioners, namely Arihant Jain and Sahil Jain, who are detained behind the bars since 28/2025 in connection with Jagi Road PS case number 193/2025 under section 61 within bracket 2/318 within bracket 4/340 within bracket 2/316 within bracket 4/306 of BNS. Learned senior counsel for the petitioner has submitted that in this case, all the offenses which are involved does not entail punishment more than 7 years of imprisonment. And therefore, there is a requirement under section 35 within bracket 3 of the BNSS to give notice to the petitioners before they can be arrested without warrant. However, he submits that in this case, there has been violation of the said requirement. He also submits that in the case of Satendra Kumar Antil versus Central Bureau of Investigation and another reported in 2022 10 SCC 51. The requirement, it was observed by the apex court that the police officer must state the facts and record the reasons in writing which led him to come to the conclusion that the arrest of the petitioners are necessary in this case. He also submits that the magistrate, before authorizing detention of the petitioner under section 487 of CRP BNSS, must also be satisfied that the provisions of section 35 of the BNSS has been complied with. However, senior counsel for the petitioner submits that in this case, the magistrate has, while remanding the petitioners to judicial custody, has not recorded his satisfaction as to why notice under section 35 within bracket 3 was not complied with. On the other hand, learned additional public prosecutors praise for calling of the case diary, as the prayer for bail was rejected by the magistrate after perusal of the case diary. Stop. It appears that while authorizing the remand of the petitioners in judicial custody, the magistrate has perused the case diary as well as case records and has observed that on perusal of the materials on record, he is of the view that arrest of the accused persons is justified. Stop. In view of the observations made by the Court of Learned, Additional Chief Judicial Magistrate, while remanding the petitioners to judicial custody by his order dated 28/2025, vis-à-vis the submissions made by learned senior counsel regarding the requirement of mentioning the reasons in the remand order, this court is of considered opinion that perusal of the case diary would be necessary for consideration of the instant bail application. Hence, call for the case diary. Let this matter be listed on third.
Friday, 3rd of September.
Can it be Friday, my lord? Yeah, apparently there is a violation.
Friday, can, today is
29th, my
Monday.
lord.
Maybe on first.
It's only from Morigaon.
Okay,
Morigaon.
on 29th of
Oblige,
September.
oblige.
29 August, sorry.
I'm sorry. I got it.
So maybe item 19.
But, as per the earlier order, a report was called for from the IO.
No FIR. No FIR.
IO has given now, a written report has been given, no, FIR one complaint is there. Complaint is there on president record, it is found that a complaint petition was received from Rahima Begum, alleging that one four-wheeler vehicle bearing registration number Scorpio has been illegally detained by the alleged accused persons. These names, four names are there, my lord. Among those, my lord, Somnath Chattopadhyay, Hijam Zeus Sinha, Pulindra Chakraborty and Raman Burman, all staff of Solamandalam Finance Company, despite of receipt of outstanding payment and issuance of NOC. The said vehicle is reportedly kept at Bajaj parking, Bahista. Now GDA entry has been made by so and matter has been presently under inquiry. So, case not registered, but inquiry is going on whether.
The Lordship will kindly appreciate what has happened in this case. Here, my lord, here one Salim Khan. He took a loan from the company, my lord, finance company. The petitioner number one before Lordship is the regional recovery manager and the petitioner number two is the area recovery manager. He defaulted in making payments. And thereafter, my lord, Lordship will kindly come to page 18. Notices were issued, he failed to make the payments, my lord. Thereafter, my lord, the company approached the civil court at, my lord, Kolkata. And a receiver was appointed to take possession of the vehicle. Lordship will see the ordered, page 18, my lord, ordered Somnath Chattopadhyay, an advocate, be appointed as receiver temporarily and for the parties for taking over possession of the vehicle bearing so and so, which is number so and so. Now, Lordship, thereafter, my lord, we came to know, my lord, during the substance of the agreement, this selling Khan, my lord, he sold off the vehicle by manipulating the documents. Because, my lord, the NOC is required from the bank. Without taking it, my lord, he transferred the vehicle to some other person. Now, thereafter, my lord, we wrote to the district transport officer, which your lordship will find at page 20, my lord. Because unless and until the bank issues the NOC, my lord, the vehicle cannot be transferred. Because it was under hypothecation. Now, Lordship, thereafter, coming to know of this, my lord, we on page 24, we lost an FIR on 6/8/2025. Page 24 at Polton Bazaar, my lord.
Yes.
Detailing the entire facts, my lord. Now, my lord, in the meantime, my lord, when the vehicle was after the vehicle was taken over position, it was kept in the parking yard. Now, what had happened, my lord? The police went to the parking yard, then they started calling us. We have nothing to do. We are just officials of the finance company. Now, Lordship, this is the Satgaon FS mill we intimated at page 28, Milord. The loanee is a resident of Gorchuk, Milord. FIR lost at Satgaon. I fail to understand that, Milord. Even then, Lordship will see,
What you intimated?
but through over 4, Milord.
No,
Milord, here it
page
is,
28.
page 28 is the Milord, by the officer here, regional legal manager, page 32, Milord.
What intimation was
The
given?
entire facts. Milord. We intimated that they just, I'll just, page 28, Milord, last paragraph, Milord. Our company, being a non-financial, non-banking financial institution, amongst other facilities, provides loan for purchasing vehicles under loan agreements to prospective purchasers on certain terms and conditions of loan cum hypothecation agreement. As per the prevalent norms, one loanee, Salim Khan, son of so-and-so, had availed loan facilities from our company for purchase of one Scorpio vehicle number so-and-so in pursuant to a loan and hypothecation agreement in which our company as financier had provided financial assistance to the tune of rupees 22 lakhs something.
Now, whether the registration certificate has been transferred
Yes,
to,
Milord.
new,
Yes.
then you cannot possess it,
No, Milord,
take
because,
possession of
Milord,
that.
because that is what the fraudulent act was done, Milord.
No, whatsoever. You cannot, without the order of the court. You had,
No, Milord. The order of the court, because there do have, Milord, on page 18, I had referred to, Milord, there is we had filed a case in Kolkata, Milord, under
Yes.
section 9, Arbitration Act, page 18, Milord.
yes,
By virtue of this order, he defaulted, Milord. We are not even aware that the vehicle was transferred. Notices were issued, he did not turn up,
no,
Milord.
if
There.
it is transferred, you have to take legal recourse.
Yes, Milord, but the vehicle was taken over possession earlier, Milord. You also will see, page 18.
Before transferring.
No, transfer, we are not even aware, Milord. What has happened, Milord? He fraudulently transferred the vehicle to some ex, Milord. We are not aware whom. The fact remains, payments were not made. We issued notices. He did not turn up. Thereafter, we approached the appropriate court bidder under section 9 of the Arbitration and Conciliation Act. A receiver was
Now
appointed.
the complaint has been lodged by the present owner.
No, Milord. I'm not, we are not even aware, Milord. We have just been called regularly, Milord. Now, but the problem is, these two officials, they have nothing to do with the case. The moment they appear, Milord, if I'm arrested. In fact, if your lordship sees at page 32, each and every document has been provided to the Satgaon police station, Milord. Page 32 encloses.
Yes.
We will cooperate, Milord. We have nothing to do. By virtue of this court's order, we possess. Thereafter, we came to know that the vehicle has been transferred to some other person. And we are taking recourse to that. We have already lodged an FIR.
Thereafter,
Heard Mr. R. Day, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioners, namely the Nizam Dius Singha, number 2, Shri Kulendra Chakraborty, who are apprehending their arrest by Satgaon Police Station in connection with a vehicle, in respect of a vehicle bearing registration number AS01FT 7507 within brackets Scorpio N bracket close, which was hypothecated to Cholamandalam Investments and Finance Company Limited. Stop. Learned counsel for the petitioner has submitted that the petitioners are serving as
Regional Recovery Manager,
regional recovery manager
Area Recovery Manager.
and area recovery manager respectively in Cholamandalam Investment and Finance Company Limited. And stop. he further submits that one Salim Khan availed loan from the aforementioned company for purchase of Scorpio N, and by entering into an loan cum hypothecation agreement. Stop. Accordingly, the company as financer had provided financial assistance to the tune of rupees 28 lakhs,
22 lakhs, my lord.
22 lakhs, 8,757
757.
to the said Salim Khan. Stop. The learned counsel for the petitioner submits that the said Salim Khan defaulted in payment of regular EMIs against the said loan, and accordingly the aforesaid company approached the city civil court at Kolkata, which stop. The said court, by its order dated 6/5/2025, passed in Miss Case number 2719/2025, appointed one Somnath Chattopadhyay, an advocate, as receivers for taking over possession of the aforesaid vehicle. Stop. Accordingly, the possession of the vehicle was taken over and it was kept in parking yard at Guwahati. However, after taking possession, the company came to know that the said Salim Khan had in the meanwhile, without informing the financer, that is the aforesaid company, had transferred the ownership of the said vehicle to a third person. Stop. Learned counsel for the petitioner has submitted that though the petitioners were not aware of lodging of any FIR against them, however, they were repeatedly called by the police of Sadgaon police station in connection with the said vehicle. Learned counsel for the petitioner has submitted that the petitioners, who are merely employees of the above mentioned company, have cooperated in the inquiry, cooperated with the police by providing all the necessary documents. Where
Page 28, my lord, the page 32, the relevant documents, my lord.
to the police. So he submits that the petitioners are ready to cooperate with the police. However, they apprehend that they may be arrested by police. Stop. If police stop. As the petitioner did not provide any information regarding pendency of any criminal case in respect of the vehicle which was above mentioned vehicle, this court by order dated 28/2025 had called for a report from the officer in charge of Sadgaon police station whether any FIR has been lodged in the said police station against the present petitioners. Stop. Learned additional public prosecutor has submitted that the office, he has filed a report,
Petition filed by one Rahima Begum.
has submitted that he has filed a written report. Okay, the officer in charge of Satgaon Police Station has furnished a report. That report has to be in the report. Whereby it has been intimated that, informed that a complaint was lodged by one Rahima Begum alleging that her four-wheeler vehicle bearing registration number AS01FT7507 within brackets Scorpio and has been illegally detained by 4 persons, including the present petitioners. All of them were the staff of Cholamandalam Finance Company. It is also submitted by learned additional public prosecutor that though no regular police station case has yet been registered, however, a GD entry was made in the police station bearing Satgaon PS GDE number 15 dated 7/8/2025 and presently inquiry is going on. Stop. Yes, what is your submission? Let them appear.
What is,
Stop.
if some document requirement they will. submit.
As stop. Next para. Let the report furnished by learned additional public prosecutor be kept in this record as a part of it. As it appears that a complaint has been lodged by one Rahima Begum against the present petitioners in respect of the aforesaid above mentioned vehicle, and inquiry is going on. There is a probability that a police station case may also be registered. And the apprehension of the petitioners of getting arrested in the said case is not without any basis. Stop. As the petitioners are ready to cooperate in the inquiry/investigation, this court is of considered opinion that their custodial interrogation may not be necessary for completion of any inquiry or investigation in respect of the above mentioned matter. Stop. In view of above, this anticipatory bail application is disposed of with a direction to the both the petitioners to appear before the officer in charge of Satgaon Police Station and cooperate in the inquiry initiated in respect of Satgaon PS GDE number 15/15 dated 7/8/2025. Stop. If they do so, stop. In event of registration of any police station case in respect of the said GD and in event of arrest of the above named petitioners, they shall be allowed to go on bail of ₹30,000 each with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions, number 1 and 2. This anticipatory bail application is accordingly disposed of
Within 7 days, I'm okay.
within 7 days.
Right.
May I not?
Yes,
I seek permission to withdraw the matter.
why?
Petitioner not wish to press the petition.
Okay. What is your name?
The-
Heard Miss A. Datta, learned counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant anticipatory bail application. Prayer is allowed. This anticipatory bail application is dismissed on withdrawal.
In the case Lordship, FIR page number 8, Lordship, registered under section NDPS Act under section 20B through capital B 29, intermediate quantity involved, Lordship, in this case. FIR
How much is the contraband?
4 kilo, Lord,
4 kilo of
of ganja, Lord.
ganja.
Ganja not recovered from me, Lordship. My name is not there in the.
Then why is the apprehension, Malad? If not recovered from
Police
him?
is asking me, Lordship.
Why
area
you are
supervisor
apprehending?
visited to my house, Lordship. Perhaps, Lordship, the arrested accused person mentioned my name in connection with this case, maybe, Lordship.
Case diary would be necessary.
Interim may be protected, Lordship. In the last para, Lordship, after completion of these formalities, so and so, on interrogation of her accordingly, she stated that above 3 narcotic substances were collected from one, namely Budullah of so and so, used to be sold at Sotia area.
What is your name?
My name is Lordship June Ali. Others, Budullah is my friend or my person here with Lordship.
Who is Budullah? Who is he?
Budullah, I don't know, Lordship. Perhaps
It is required, Malad.
Case diary.
interim.
Heard Mr. ABT Hawk. Heard Mr. ABT Hawk, learned counsel for the petitioner. Also heard Mr. KK Parashar, learned counsel, learned additional public prosecutor. Considering the nature of accusation made in the FIR, the perusal of the case diary would be necessary for consideration of the instant bail application. Hence, call for the same. Short date. Let this matter be listed on 5th of August, 5th of September.
Item 48 from supplementary list.
Yes.
F-28 application also against the offense report filed by the forest department. The petition people, your lordships are all the residents of Arunachal Pradesh. The alleged allegation is that they have encroached upon the land while construction of the road under the Pradhan Mantri Gram Sadak Yojana. And there is apparently a inter-state border dispute. That document I have annexed, your lordship. So the offense report, the English translation, my lord, will find it page 18.
Which?
Page 18, my lord. The allegations has been, offense report has been filed under section 24-25 of the Assam Forest Regulation. May I first read the offense report, my lord?
Yes.
The complete description of the incident is that on 21/10/23 at about 11:15 AM, I along with my colleagues and border security force went for patrolling to northern side of the mountain of Segun Red Reserve Forest planted by joint Rampur Deori Forest Managing Committee. It is found that by cutting a mountain-like embankment was made while constructing PMGSY road by the Arunachal government inside the Red Forest. This work was executed with an object to encroach the land of Assam by the people of Arunachal. The divisional forest officer Harmati was informed over mobile phone relating to the said incident. While informing the Kimil circle officer relating to the encroachment made by the people of Arunachal, he abused us and also threatened to get ourselves dismissed from service. As per previous verbal discussion, there has been arrangement for joint patrolling by the state, by the government servants of the border areas of both the states. Unfortunately, on being informed about the incident of encroachment, instead of cooperation, on the contrary, they threatened and abused us. In the further discussion, it was stated that if only one party would patrol the border areas, then law and order situation may arise or may generate agitation.
On seeing our patrolling party at the place of encroachment by the Arunachal people, the people who were present at place of occurrence went away to some distance. Our party returned back in apprehension of the problem that may arise at the said place. The employees of Harmoti Anchal Beat Forest Office, employees of Kimin Beat Forest Office, the employees of Rampur Forest, the Jawan of Border Security Force, and I again went to the place of encroachment at 2:45 p.m. The Arunachal people who were present at that place made altercation with our patrolling party. It is seen that a canal of 20 by 10 by 8 feet was dug in the middle of the place 180 meters far from PMGSY road by cutting mountain like an embankment. While taking the photo of that place, they obstructed to do so and informed that the said work is executed after taking LPC, the land possession certificate, my lord, and necessary NOC of the Arunachal. Keeping in view the situation, our party returned back from the said place immediately. On 21/10/23, a written report was submitted before the officer of Harmoti Anchalik Forest relating to the incident. On the said day itself, the officer in charge of Siloni Bari was informed relating to the said incident through a notice exhibit 1. On 22/10/23, application was made before the officer in charge. These are the exhibits all about. And the relevant part now, my lord, is the last paragraph. Therefore, it is humbly informed that to your honor, that by destroying the red forest, the encroachers have committed an offense of violation of the pending case before the Honorable Apex Court regarding disputed border boundaries. As such, a case is registered against the encroachers and a complete report is submitted for necessary action and for doing justice. Now, my lord, kindly see. These are the from page 29 onwards, my lord. Page 29 onwards. This is the land documents issued by the government of Arunachal Pradesh, Office of the Additional Deputy Commissioner, Kimin Circle, Papumpare District, my lord. These are 5 series. This is the certificate dated 26 June 2020. And the alleged incident is of 21/10/23. This is in the name of Sri Lokam Talo, the petitioner number 1, my lord. Now, your lordship will kindly turn to page 30, my lord, for a moment. At the page 30, at the top, there is a, in the press map, my lord, have whether got it?
Yes.
There is a mention of PMGSY road at the top. And
Yes.
just behind that PMGSY road, these are the continuous plot of land of the petitioners. The petitioner number 1 is the father of petitioner number 3, 4, and 5, and of husband of petitioner number 2. These are all the lands belonging to the same family, my lord. Now, if this PMGSY road is within the border of the Arunachal Pradesh, and just behind this road, the land is situated, and against which this land certificates in the name of the respective petitioners has been issued. This page 31 is issued in the name of his wife, the petitioner number 2, Lokam Yabi. Now, page 33, my lord, this is issued in the name of the petitioner number 3, his son, the Lokam Tana. Similarly, my lord, page 34, it is the land possession certificate issued by the Lokam Tanga, the petition number 4. And page 37, my lord, it is issued in the name of his son, the Lokam Tiger. These, my lord, the allegations are totally frivolous. This is the petition number, so number 3, 4, and 5 are the students. These are aged 18, 20, and petition number 5 is only 7 years, my lord. How he can go and excavate as the allegations has been made. Now, kindly see. Page 40, my lord. Page 40, this is the inter-government meeting regarding the border dispute. Government of Arunachal Pradesh, Office of the Deputy Commissioner, dated 19 January 2023. This is the forwarding of minutes of the regional committee meeting held on so and so, 9/1/23. I am enclosing here with a copy of minutes of the regional committee meeting of Papumpare, Lakhimpur, Biswanath districts on Assam Arunachal boundary held on 9 January 20. This ought to be 23, my lord. It is written as 22, typography error. In the conference hall of Finance Department, Civil Secretary, Itanagar, for kind information, necessary action. Now kindly see, my lord. This is the page 43 is the relevant. The petitioners are all residents of Arunachal under the Kimin Circle and the resident of village Kelo 2. And in the Kimin Circle at column 3, my lord, will find column 3 B. B is relevant. Belo 2, Lora 1, Lora 2, and Kimin are proposed by the Assam Regional Committee to be considered a single cluster as per present status of possession. This present status of possession is with the government of Arunachal Pradesh, my lord. Accordingly, these certificates of the lands possessed by the petitioners has been issued by the government of Arunachal Pradesh. This meeting is dated 9/1/23, my lord, 19/1/23. And the alleged incident there stated is to be of 21/23. Land documents certificate has been issued on 26 June 2020, my lord. As on date of the meeting also, there is an apparent admission that there is a border dispute as regarding to this Kimin circle also. Now subsequently, my lord, on 2/2/24, the trade license has also been granted by the government of Arunachal Pradesh regarding the carrying out, running the resort. But presently, because of lodging of this case, the work has been stopped. Now, for a moment, now I will take your lordship to the relevant provisions under which this case has been lodged.
Where is the order of taking cognizance?
Yes, I also challenged that, my lord. At
Where-
page
where?
29.
Page?
Page 29, my lord. Page 29. Order of cognizance, sorry, my lord, page 28. Page 28. By order dated 4/10/24, this cognizance was taken. Now your lordship may kindly peruse this. This case is registered under section 24 and 25 regarding the encroachment and clearance of the forest as alleged. But by virtue of section 26, my lord will kindly see. This, section 26, acts exempted from section 24 and 25. Nothing is an offense if the said act of possessing of the land is with the previous sanction of the government. B, the exercise in accordance with the rules, if any, made by the state government under section 13 of any right continued under that section. C, the exercise of any right created by grant or contract in manner described in section 21. Any act done with the permission and writing of forest officer, especially empowered to grant such permission. With all humble submission, my lord, this land certificate is issued after proper on the spot verification made by the revenue authorities by taking consent and clearance from the forest department as well as from the Gaon Buda. So apparently, my lord, there is an interstate border dispute against which a meeting has also been held, and I am possessing this land duly certified by the government of Arunachal Pradesh. This is dated this prior to the incident. I am holding this land since very long time, but the certificate has been issued on 26 June 2020, my lord.
Yes, Mr. Sharma.
My lord, the first thing, my lord, the taking order of taking cognizance, my lord, that is not in my copy, my lord.
How?
Maybe, that is after 27, after 27, it is 29. So, my lord, that is the main contention, my lord. And my lord, in the offense report, my lord, it is clearly mentioned, my lord, that clearing jungle, my lord, that is the forest offense, my lord, in my lord, the Assam Amendment in 1995 also. And my lord, petitioner has challenged, my lord, that the cognizance order, my lord. If, my lord, there is anything, my lord, that is to be challenged, my lord, that's offense report, my lord. But, my lord, in the taking cognizance, my lord, that is not anything wrong, my lord, because, my lord, acting on this offense report, my lord, the honorable court has taken cognizance that, my lord, and my lord, clearly, they are maybe from, my lord, Arunachal Pradesh. They are resident of Arunachal Pradesh, but, my lord, enforcement is, my lord, that is, my lord, there. And, my lord, it is, my lord, Assam land. My lord, Assam forest, my lord, can act on, my lord, Assam forest. Cutting off earth, my lord, unearthing the, my lord, forest. That is all is there, my lord. And honorable court taking cognizance of that, my lord. So what is the wrong, my lord, in taking cognizance of that, my lord, offense? It is clearly a forest offense, my lord.
With all respect,
And, my lord, kindly see the, my lord, prayer portion, my lord. The only, my lord, the there, my lord, challenge, my lord, the honorable court's order taking cognizance. My lord, the offense report is not, my lord, challenge. If there is anything, my lord, in the offense report.
Okay. Heard Mr. G. Jalan, learned counsel for the petitioners. Also heard Mr. B. Sharma, learned special public prosecutor.
My lord, respondent number 2, my lord.
Appearing for respondent number 2.
One,
Also heard Mr. K. Parashar appearing for respondent number 1. This application under section 528 of BNSS 2023 has been filed by the petitioners, namely Shri Lokam Talo 1, 2, 3, 4, 5, praying for quashing of the complaint case bearing number CR, bearing CR within bracket F, case number 15/2023, pending before the Court of London, Judicial Magistrate First Class, in Lakhimpur, under section 24, under regulations 24 and 25 of the Assam Forest. Assam Forest
Regulation
Regulation
Act 1891 within bracket as amended in 1995.
under sections 24 and 25 of the Assam Forest Regulation Act 1891. The gist of the facts relevant for the facts relevant in this case in brief is that 1, offense report has been filed on 28/10/2023 under sections 24 and 25 of Assam Forest Regulation 1891 before the Court of London, Judicial Magistrate First Class, Lakhimpur, inter India, alleging that on 21/10/2025, the complainant, who is a forest official, along with his colleagues of the complainant, along with his colleagues, as well as personnel of Border Security Force, went for patrolling to the northern side of the mountain of Segun Red Reserve Forest. And during patrolling, it was found that that while constructing PMGSY road by Arunachal Pradesh government inside the Red Reserve Forest, a mountain-like embankment was cut and encroachment in the land of Assam was made by the people of Arunachal Pradesh. It was alleged that by destroying the Red Reserve Forest, the encroachers have committed offense of violation of pending case before the apex court regarding disputed border boundaries. And as such, a prayer was made for taking cognizance of the case. Stop. Accordingly, on 4/10/2024, London Judicial Magistrate First Class, by passing the order on the said date in CR within bracket F, case number 15/2023, took cognizance of offense under section 24/25 of the Assam Forest Regulation Act 1891. Stop. 1891 against the present petitioners. Stop. learned counsel for the petitioners has submitted that the petitioners are inhabitant of Kimin Circle under Papumpari district of Arunachal Pradesh. And they are holding land possession certificate in respect of land where the excavation work was made. In support of his submission, the learned counsel for the petitioner has annexed the land possession certificates in the name of the petitioners. He also submits that a border dispute is going on between two states, and in this regard, a meeting was held on 9/1/2023 of the regional committee of Papumpare Lakhimpur Bishwanath Charali districts of Assam and Arunachal Pradesh. And it is further submitted by learned counsel for the petitioner that in the said meeting, it was resolved that as regards covered land falling under Kimin Circle, the
Close B, my.
the land which falls under Belo -2, Lora -1, Lora -2 and Kimin were proposed by the Assam Regional Committee to be considered as single cluster as per the present status of the possession. Learned counsel for the petitioners submits that the land in question is under the possession of the petitioner since very long, and whereas the land possession certificate were issued only in the year 2020. He submits that as the cutting. Learned counsel for the petitioner also submits that as the petitioners were possessing the land, aforesaid land, as per the land possession certificate issued by the government of Arunachal Pradesh, the no offense under section 24 and 25 of the Assam Forest Regulation Act 1891 has been committed, as same is exempted by virtue of the provisions contained in section 26 of the said regulation. Stop. On the other hand, learned special public prosecutor submits that as the petitioners were found illegally extracting land which is within the territory of the state of Assam. The trial court has rightly taken cognizance of the offense under section 24 and 25 against the petitioners. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record, including the copies of documents annexed along with the petition by the petitioner, which shows that the petitioners are the holders of land possession certificates in respect of the disputed land. Stop. Let the records of let the scan copy of the records of AR within bracket F case number 15/2023 be called for from the trial court. Stop. The registry to take steps for requisitioning the above mentioned scan copies. At what is the stage now?
The next, tomorrow is the date of appearance. In the meantime, my lord, the returnable date will be.
Stop. However, considering the submissions made by learned counsel for the petitioners, as discussed in the foregoing paragraphs, further proceeding of complaint case bearing number CR within bracket F 15/2023 shall be kept in abeyance till next returnable date. Place this matter again on longer date. 25/9. 25/9.
May please, your lordship. On the last occasion, the amended cost title page was not tagged with the record. As there is POXO,
Case diary is there.
No, Lord. He has something issued.
You have taken steps for issuance of notice.
was under impression that notice was not issued as because the cost title page was not there on the last occasion.
Okay, we are issuing notice.
Lordship.
Heard Mr. A.R. Shom, learned counsel for the petitioners. How many petitioners are there?
Only one.
Petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Since offense under POCSO Act is involved in this case, hence issue notice to respondent number 2. Stop. The petitioner shall take steps for issuance of notice upon respondent number 2 in pursuant to the prevailing notification of the registry in this regard within 3 days from the date of this order, returnable on 16/9. Case diary is there.
No, no, CDS from
Issue reminder for the case diary. List accordingly on 16.
Oblige, Lord.
Bail hearing be item 22.
Okay.
Lordship, my senior is then late in another court. Kindly pass over the matter to kindly.
Let him come.
I give like. Same to your Lordship.
May I proceed, madam, my part?
No, let him come, otherwise. What is the matter?
My lord, it's a NDPS charge sheeted case where, my lord, the grounds of arrest were not given. And 4850A was not served. And one more point, my lord, I want to raise, my lord, with regard to the memorandum of arrest, my lord. The mandate
Then,
state,
then let him come.
my-
Let-
can it be at two, my lord, or?
Two Lordship, at two Lordship.
Okay, at two.
I give like.
Yes, my lord, office note indicates that, office note date is 21st August indicates that we have not taken steps, but actually we have taken steps on 19th. But it was not shown. So,
You have the acknowledgement of taking steps.
47 serial number. In computer, your worship may see.
No, you get a acknowledgement slip when you submit. Whether that slip is there.
Right. Instrument number 47. my lord. But that is no way disputed.
Then you find out whether it is served or not, if they have taken steps. Heard Mr. A. Paul, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Though office note dated 21/8/2025 shows that the petitioner has not taken steps for issuance of notice upon respondent number 2. However, learned counsel for the petitioner has submitted that the steps were taken by the petitioner on
Actually, we have submitted on 19, but office note receipt shows it was received on 21 due to some technical issues in there.
you have the acknowledgement
Yes,
receipt.
It's taken verified lordship, if
Okay.
indeed it was taken on 21.
On 19th,
No, 21.
and same was received by the registry on 21/8/2025. So the registry is directed to verify the same from record and put up an appropriate office note in that regard on the next date
My lord,
fixed.
that date, my kindly wish taken up 5 or 8 of September.
Let this matter be listed again on 5th.
In the meantime, I have an additional pair because lordship on being going through the scanned copy of LCR. It is seen that till charges against has not been framed against any person till date. And moreover, with regard to the inspection memos, there are some violation of arrest also. So let me file an additional affidavit by taking the side ground as per law.
Stop. Learned counsel for the petitioner has also prayed for allowing the petitioner to file an additional affidavit to bring on record certain relevant facts. The prayer is allowed. The petitioner may do so before the next date fixed. List accordingly.
Date is my lord, 5.
5th,
Yeah,
or you want it on 8th?
No, 5. In between, I am filing it just today or tomorrow.
Okay.
Obliged.
Into forest case, or forest case.
CD has not been received.
May I please, your lordship? My lord, also section 12 is there. And the petitioner is behind the bar for lordship 45 days. The last of us.
Whether notice has been served.
See, we do not have that information. CD also not received. lordship.
On the last occasion also, CD was not received. And instruction.
What is to be done?
Lordship may fix a short date, lordship, from Bongaigaon.
Heard Mr. M. Khan, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who submits that some more time may be granted for production of the case diary. He also submits that he has not received any information regarding the fate of notice issued to respondent number 2. Stop. In view of the submissions made by learned additional public prosecutor, the prayer is allowed. Stop. He is however requested to take information regarding the fate of the notice issued to respondent number 2 from the concerned officer in charge of jurisdiction, from the officer in charge of jurisdictional police station, and let this court know about the same on the next date fixed. Let this matter be listed.
Thursday, lordship.
5th
25th
of September.
26.
Short date. It is a short date.
Short date, lordship, because
5th is
more than 55, it will be mandatory 60 days. Can it be on Friday, lordship? Because earlier two occasion, lordship, they took time. Friday or Thursday, lordship. So let it be on
if
the
CD does not
What
arrive
3rd of September.
3rd of September.
Item 28.
Maybe the lordship. Citizen are behind the
Maybe
57.
second, I have to go through the use.
CD is there.
CD is there. I have to-
Let him go through.
60 days mandatory period more than.
Taken up. 29 days in office not lordship, probably the scan copy has not been received. Scan copy was called for also in the last day. There is an office not lordship.
It should be already. Wait, please.
Just yes.
Even grounds of arrest is not there in case number 35 and 36 lordship. Notice under section 50 CRPC. 50A.
When were you arrested?
Arrested on
5
5
to
to
5,
25.
24.
25 or
24, sorry. 20.
So I have to go to the LCL also because there was an office not lordship. I thought scan copy. has not been
the LCR, the scan copy which is available
lordship.
was requisition in connection with a different case,
Lordship.
which is arising out of the common police station. Therefore, registry has tagged this.
Lordship. So their main contention is regarding non-furnishing of grounds. So if I can verify that lordship, then.
Okay, let him go through
Lordship.
after some time.
I am late and HRA surgery will be leg lordship. Can be taken up after some time.
Okay. After some time.
Yeah, please, your lordship. Okay. At 2 PM, lordship.
Why?
Lordship, Islam is another court in this case.
No, lordship, here lordship, kindly see, there's a, by order dated 31/7, notice was issued lordship to the respondent number 2. Lordship will kindly see the office note. Steps was taken on 22/8/25 lordship. How is it expected the reply will be there lordship? On 31/7 lordship, notice was issued.
Oh,
They have taken steps on 22/8 lordship.
then we have to wait.
And not a short date maybe Friday. 441 days in the month.
No,
You should have taken
you,
steps
you,
on
you have taken steps after 1 month. We have to wait. Heard Mr. M.A. Mondal learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. It appears that though the petitioner was directed to take steps for issuance of notice upon the respondent number 2 within 3 days, that is, within 3 days from date of the order, within bracket 31/7/2025. However, the steps for the same were taken by the petitioner only on 22/8/2025. Stop. The service report has not yet been received. Considering the above aforementioned facts, await further. Let this matter be listed
That will be on Lordship 9th of September.
9th of September.
Please, your lordship. My lord, I appear in 52 for Amrendra Kumar Singh.
As they are not.
Am I audible, my lord?
Yes, the trial court records have
sorry?
not yet been received.
Could I persuade your lordship to have the arrest memo in the notice on page 10 and 11? Even otherwise, my lord, there are the grounds of arrest are not mentioned in either the arrest of memo or the notice of arrest. So on this score alone, my lord, my case would, I humbly submit, be covered by a lordship's judgment, which I had appended, and that of a coordinate bench, that the grounds of arrest are not mentioned as under section 50, that itself vitiates the proceedings, my lord. Your lordship's kind.
It is a
Movement, my lord.
NDPS Act. Offenses under
NDPS
NDPS Act.
Same. But in the case in which your lordship's pleasure was to grant indulgence, that were
No.
also NDPS matters,
No,
my lord.
as because the offense is under NDPS Act, perusal of the case diary is necessary because apart from 47 and 48 notice, under 52, also the grounds of arrest are to be intimated.
My lord, even in the notice, your lordship will find they are not mentioned. May I humbly submit that, my lord? And one
No,
thing I may indicate, my
in
lord, the
47
petitioner is
your-
so poor. I'm sorry. Your lordship on the last date had posed a query to me regarding the applicant delaying the proceedings, my lord. May I humbly indicate, my lord, that he is so poor that he had to resort to legal aid there, my lord. So the question of applicant delaying the proceedings doesn't arise, my lord. And he has been languishing in jail since September 2021, my lord. It's been 4 years now.
Why the
That
10 copy has not yet been received? It is into Roberto Cobo. Telephonic instruction come scan copy. We are fixing a short date for the scanned copies.
I'll be grateful, man. Deeply obliged, my lord.
Heard Mr. S. Sharma.
Lordship is Shivam Sharma.
Shivam Sharma, learned counsel for the
Man.
petitioner appearing through video conferencing. Also heard Miss M. Deka, learned counsel for NCB. The office note dated 22/8/2025 shows that the scanned copy of the trial court records have not yet been received. Issue reminder for the same. List this matter on 5th of September.
Grateful, my lord. Much obliged. Behold.
Item. 0. Yes.
For city.
They did not receive the.
You are on interim bail.
I am on.
Heard Mr. N. Islam, learned counsel for the petitioner. also Miss N. Das, learned additional public prosecutor, who seeks some more time for producing the case diary. Prayer is allowed. Let this matter be listed again on 24th September. The interim order shall continue till next day.
31.
Wait, please, my lord.
Steady receipt.
CD is there?
Yes, sir.
Yes.
Wait, please. My lord, similarly situated persons have been granted the privilege of absolute bail by this honorable court. If my lord kindly has page 44 onwards, my lord, there are two orders passed by this honorable court.
In the same case,
Same case, my lord, arising out of the same FIR, my lord, Junai PS case 37 of 25, my lord. Same FIR, similarly situated persons, 21 of them have got the privilege of absolute bail. In fact, it's my lord's order.
And lordship, order dated 12/6/25. The petitioner number 6, Dhorna Tarok Pegu, his interim bail was vacated and the bail was rejected, lordship, earlier.
who are you?
My lord, we are 6, my lord.
Jharna is also there.
Charna is also
Yes.
there. Because, my lord, for Vikas Pegu, matter has become infructuous, my lord, because he has been arrested during the
Yes.
pendency of this case. Now the case only remains for Falguni Pegu, applicant 2, Utpal Pegu 3, Onil Pegu 4, Hiren Kutum 5, and Jharna Tarak Pegu 6. Otherwise, my lord, even
Dhorna Tarok Pegu's lordship bail was earlier rejected and interim was vacated on 12/6/25.
Yes,
So then-
against Janatara Pego, materials were found. And therefore, when it was rejected,
My lord, 12/6/25, my lord.
12/6/25, lordship.
Page 44 onwards, my lord. My lord, would kindly have page 44. Effective portion is at page 51, my lord. Paragraph 13.
no, yes, what is your submission?
My lord, my submission is that, my lord, we are ready to cooperate with the investigation, my lord. Since, my lord, similarly situated persons have already been granted the privilege of absolute bail, my lord. And we are not in any way involved, my lord. There is a counter FIR which one of the applicants, my lord, Mr. Vikas Pegu had filed in the instant case, my lord. This case, my lord, arises out of a political enmity, my lord. If my lord kindly has, my lord, page 31, my lord.
No, just,
Yes.
And lordship, as per the order dated 4/6/25, section 103 also, BNS also added, lordship. Lordship, this is not a fit case for anticipatory bail application, lordship. And lordship,
against others,
against others, lordship, materials are there, lordship, implicated by the informant and eyewitnesses, lordship, are there, lordship.
against whom?
Against 2, 3, petition number 2, 3, 4, 5, 6, all of them, lordship. And lordship, during investigation, found that the absconding accused, Jharna Tarak Pegu, Falguni Pegu, Utpal Pegu, FNM accused person are another criminal case, lordship also registered, lordship, and which was charge sheeted, lordship, under section 189, 189, 4, 117, 324, 4, lordship.
PS case number.
PS case number 39/25.
My lord, there we are not involved, my lord, 39.
Otherwise, lordship, in this case, lordship, eyewitness are
My
there,
lord, if
lordship.
this is a new.
You flag,
Yes, lordship, I have flagged everything.
heard Mr. P.R. Sharma, learned counsel for the petitioner. Petitioner also heard Ms. N. Das, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioners, namely Vikas Pegu, Falguni Pegu, Utpal Pegu, Anil Pegu, Hiren Kutum, and Jharna Tarak Pegu, who are apprehending their arrest in connection with Jonai PS case number 37/2025 under section 61 within bracket 2/189 within bracket 2/109/117 within bracket 2 of BNS with added section
Section 103, subsection 1.
1031 of BNS. The gist of accusation in this case. Code para 3 from page number 48. Learned counsel for the petitioner has submitted that during pendency of this anticipatory bail application, the petitioner number 1, namely Vikas Pegu, has already been arrested, hence, this his prayer for anticipatory bail has become infructuous. Stop. As regards other petitioners, he has submitted that they are falsely implicated in this case as a result of political rivalry in connection with panchayat elections which were held in the month of May 2025. He also submits that in the meanwhile, how many co-accused have been released?
21, my lord, 21.
21 co-accused persons have already been released on anticipatory bail.
My lord, regular bail and both anticipatory bail.
On bail. And the petitioners also stand on the same footing. So he further submits that the petitioners are ready to cooperate in the investigation and therefore their custodial interrogation may not be necessary for fair completion of the investigation. Stop. On the other hand, learned additional public prosecutor has submitted that the petitioner number 6, namely Jharna Tarak Pegu, was earlier granted interim anticipatory bail. However, after perusal of the case diary, this court, by its order dated 12/6/2025, had vacated the interim anticipatory bail and our prayer for anticipatory bail was rejected. Stop. He submits that against all the 6 petitioners in this case, there are sufficient incriminating materials in the case diary. He also submits that the witnesses whose statements were recorded during the investigation have implicated the petitioners regarding their complicity in the offense alleged in this case. She therefore submits that this is not a fit case for grant of anticipatory bail and therefore prays for rejecting the prayer. Stop. I have considered the submissions made by learned counsel for both sides and have perused the case diary. Stop. I'll peruse the case diary and pass orders in chamber.
My lord, may I just have one last submission, my lord? Just I'll take 1 minute of this honorable court's time.
Yes.
My lord, would kindly have page 31 for a moment, my lord. We had also filed one FIR because the said Vikas Pegu, my lord.
Yes, that I have dictated.
My lord, my lord, we had filed, my lord, in that FIR, my lord, we had stated that we have no role with the said incident. It was in fact one Arman Lagasu who had brought his goons and had carried out the said misdeeds. If that could kindly be added.
Page number.
To show our bona fides, my lord. Page 31 it starts, my lord. 31. 31 is our Ejahar, my lord. 31, 32, may I read if it pleases, my lord? We had filed it on, lost this on 2/5/2025, my lord, 1 day prior to the filing of the informant Ejahar. Informant had lost it on 3/5/2025. That may kindly also be added, my lord, if it pleases, my lord. Because, my lord, they have come late, my lord, the informants, my lord. We are being prejudiced because of that, my lord. Then, my lord, there is a medical report also, my lord. 41, if my lord has for a moment, and 43, my lord. We have also sustained injury, my lord, with the said Vikas Tego, my lord. Head injury.
It has to be added in the submissions of the counsel for the petitioner. Learned counsel for the petitioner has also submitted that said Vikas Pegu in his affair has alleged that one Dharmen Lagasu had assaulted the petitioners.
My lord, the said petitioner, my lord. Owing to the same, he had received injuries. my lord.
Had assaulted
Head injury.
said Dharmen Lagasu, which shows that the present petitioner do not have any role in the offense alleged in the FIR. Okay, I'll go through it.
The petitioners have no role. Not only.
You give the case here.
Deeply obliged, man.
Chamber of the
It is a block.
May I please, my lord, this is 482 application seeking anticipatory bail. My lord, my previous bail application was rejected by this honorable court. And that particular order I have annexed at page 39, my lord. This is the order by which my earlier anticipatory bail application was rejected. And the operative portion lies at page 41, my lord, at para 13. May I allow to read, my lord? There are sufficient incriminating material against the petitioner in the case diary. Moreover, it also appears that he has misused his liberty when he was granted bail by the court of the learned additional session judge Nagaon in BA case number so and so. Now, firstly, my lord, I would like to take my lord to the FIR, and that FIR, my lord, will find at page 17. This is the vernacular FIR, my lord. I would like to read the SMS version of the FIR. My lord, may kindly come to the FIR first, because in this case, FIR speaks a volume in this matter. Page 75.
Yes.
My lord, here, my lord will find that the informant is one, Dilip Pal. And there are two accused in this case, my lord. One is Bibha Bora and another one is Unil Raspal. Now I am coming to the content. May I allow to read, my lord? বিনীত সন্মানপূৰ্বক নিবেদন সহকাৰে আপোনাক জনাও যে মোৰ নামত থকা এনঅচি নাম্বাৰ সো এণ্ড সো নম্বৰৰ এনঅচিখন মই শ্ৰী দিলীপ পাল পিতা প্ৰয়াসী মোহন পাল গাঁও হুৰাগাঁও থানা মায়াং জিলা মৰিগাঁও লোকজনক বিক্ৰী কৰোঁ বৰ্তমান জানিব পোৱা মতে উপৰোক্ত 1 নম্বৰ আসামীজনে মোৰ নামত থকা মাটি কিনা বেচা কৰা এনঅচিখন চক্ৰান্তমূলকভাৱে ইংৰাজীৰ 10/11/2022 তাৰিখে জালিয়াতি কৰি উলিয়াই নি এডিট কৰি 2 নম্বৰ আসামীৰ লগত মাটি বেচা কিনা কৰে কিনা বেচা কৰে Now, my lord, if my lord see in the affair, there is no specific allegation against accused number 2, who happens to be me, my lord Unil Raspal. The specific allegation is that it is the accused number 1 who has forged the NOC, which was originally in the name of the informant. And secondly, my lord, if my lord see in the affair, there is no victim in this case. Because after obtaining the NOC, informant has sold his plot of land to one Dilip Pal. Here in this case, both the informant as well as to whom the informant has sold his land is also Dilip Pal, my lord. So he might be aggrieved, but there is no apparent victim in this case. And coming to this case, my lord, in terms of the accused number 2, there is no apparent reason even for the accused number 1 to forge a particular NOC by which she has sold her property to me. And reason being so, I would like to take my lord to page number 45. My lord, may kindly come to page number 45. My lord, may I make a request, my lord? Your lordship attendant has come. So is it wise to take up this matter at 2, my lord?
Okay, we'll continue at 2.
Okay,
But
please
you have
go
to
ahead,
satisfy
my lord.
what new grounds do you have? Because once this has been rejected, you made similar submissions earlier also.
No, my lord, because earlier there are certain
So you
documents.
have to satisfy at 2.
Yes, my lord.
Why this anticipatory bail subsequent?
May I please, my lord? No, before the break, my lord has posed a challenge to me. Before going into the matter, I have to satisfy my lord that there is a subsequent good ground which can be considered by this honorable court. Now, my lord, these kind of grounds can be both factual as well as legal. Now, my first factual ground is that, my lord, by way of additional affidavit, I have brought on record regarding a case, my lord, where the accused number 1 is a star witness in a case where her own brother has been killed, my lord. And that particular case is going under trial, my lord, before the Honorable Session Additional District and Session Judge, Nagaon. Now, my lord, my second ground is a legal ground.
Now, how it helps you?
Yes, my lord. Now it might help that there is no
How it helps you?
No, my lord, this is going to help me because this is an affair that has been lodged to derive a diluted statement of accused number 1 in that particular case where he is a star witness and her own brother has been killed by. That particular facts I have brought on record. And my second ground is a legal ground, my lord. No cognizable and non-bailable offense has been made out in this case, my lord. And my third ground is that there is a substantial delay in lodging of the affair. And that apart, my lord, this is not a case where custodial interrogation is required because the case needs to be proved by way of documentary evidence. These are my basic grounds, new grounds, my lord.
Yes.
Custodial lordship intervention is required because lordship, the modus operandi lordship of the case, of the whole network, legal criminal gang, still to be revealed, lordship. And lordship, statement of lordship, during investigation, lordship, it was also found that
No, my
the
lord.
Anil Rajpura, lordship,
Let him.
Anil Rajpura's son, Masum Rajpura, the owner of the land, person namely Harendra Saikia, is mentally disabled since long year as per the statement of his family and Gao Pradhan. Gao Pradhan's lordship certificate is annexed here with the case diary, lordship. And also a written copy was produced by Gao Pradhan as the person is mentally disabled who never can sign and could not go out from his house and bed. How he can put signature, lordship?
My lord, to that effect, my lord, Mosam Raskwa has been granted bail in this case, my lord.
They
By
stated
this honorable
they
court.
never go
And
to
secondly,
circle
my
office
lord,
and sub
my
register
learned-
No,
office.
no, let her make her.
Deeply,
comment.
let her.
Lordship, they never go to circle officer and sub register office for the sign in the sale deed. And owner of the land, namely Rongali Rajpura, was not sold her land and she never signed in the sale deed. The original sale deed of Sonali Borwa in record of sub register office, there is no sign of Rongali Rajpura, but one duplicate sale deed was produced at PS by Sri Onil Rajpura, where there is a sign of Ronali Rajpura. And also fake NOC also seized from this Anil Rajpura lordship. Sufficient materials are there, lordship, and your lordship already rejected. So what is the new grant, lordship?
First of all, my lord, Sonali Rajpura is not an accused in this case. In what context my learned friend has brought her, I could not understand. because she is
There is
not
a
the
link,
accused in this
Lordship.
case. My lord, so far as the Masum Raspa, কি বলে আপনি? Mosam Raspa is concerned, my lord. He has already been granted bail by this honorable court. And secondly, my lord, here is the allegation is specific, my lord. There is a specific allegation in the FIR that one NOC has been committed, one NOC has been forged by accused number one.
No, regarding the observation made by this court that you misused your liberty while on bail.
So, my
Granted.
lord, I have never misused my liberty, my lord.
Lordship,
And
one,
that I will satisfy if my lordship give me some moment so that I can go through this case.
Okay, then we'll take it up tomorrow. You go through the matter.
My lord, tomorrow. Deeply obliged, my lord.
How, because the grounds on which the anticipatory bail was rejected on earlier occasion.
Yes, my lord.
One of the main ground was you misused your
My lord,
liberty.
I never
Yes,
misused my
Lordship,
liberty.
may I point
The-
one, Lordship,
There is
one.
no reason for me to misuse my liberty. Why
No,
would I
you
go
want to go through what?
My lord,
You
my
want,
lord, I want to go, take my lord to my petition. so
No.
that I can, yes, my lord, even now, or my lord tomorrow, my lord may fix this matter at 2 then, tomorrow.
Lordship, I want to just point out one thing, that Lordship, the Anil Rajpura, after getting liberty, he approached the informant and put pressure to withdraw the complaint, and complainant verbally informed the
My
PS,
lord,
and this regard a general entry has been made, and GDA entry number is there, Lordship. General entry has
okay,
been
okay.
made, Kamrup PS
You have
GD
a
number
very weak
87.
case. You have a very weak case.
my lord, I have drawn.
But I'm granting you time till tomorrow. We'll take it up again. Otherwise, what additional PP has submitted,
Yes, my
it
lord.
is unlikely that you may get bail.
No, my lord.
But I'll hear you tomorrow.
Deeply.
Heard Mr. B. Dekar, learned counsel for the petitioner. Also heard Ms. N. Das, learned additional public prosecutor. During the course of hearing of this bail application, learned learned counsel for the petitioner has prayed for some time to go through the brief before he makes his submission. The prayer is allowed. Let this matter be listed tomorrow at 2 p.m.
Deeply obliged.
Pejari shall be retained till tomorrow. After some time. After Amarlis Mata Pisamat.
Item 22. Yes, we must find an-
It's a revision against the judgment of appellate court, Sessions Judge Yellow. The learned trial court of division of first class convicted the appellant.
What was the urgency?
Ultimately, your lordship is 30 days time is granted, page 36 of the petition, 30 days time granted for filing appeal before the High Court, and today is the 30 days is completed.
You are on bail.
Lordship.
You are on bail.
Your lordship. I am raised a bail here. Page 36 is the order, your lordship. Page petition so and so, paying for allowance.
What was the punishment?
Punishment 6 months here, conviction for 6 months.
Okay.
3 petitioners.
Heard Mr. S. Islam, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. This revision petition has been filed under section 438, read with section 442 of BNSS by the petitioner, namely Johirul Haq, impugning the judgment dated 23/7/2025 passed by learned additional session judge Dubri in criminal appeal number 3/2021, whereby the petitioner was convicted under section 341. What was the punishment? 6 months for each offense?
No, Your Lordship. Earlier, there's a trial court judgment, Your Lordship. Trial court convicted under section 341, 342, 320 under for fine only. After that, against that, the victim has filed an appeal against the order. And that, after that, the appellate court has passed order and convicted, increased the conviction, Your Lordship, to 6 months, including that fine also.
6 months against which offense?
Against same year, 323, 34. Page 49, Your Lordship.
323, 34.
Lordship. Page 49, Your Lordship. Over the top.
Petitioner Johirul Islam Hussain, or Mufida Bibi and Bhola Ali. 3 petitioners are there. Whereby the appellate court, that is Court of Additional Session Judge Dubri, modified the sentence imposed on the petitioners to imprisonment for 6 months. Along with the fine which was imposed on the petitioner by the trial court. Stop. Learned counsel for the petitioner has submitted that. Where is the bail order?
Your Lordship, page 36.
Submitted that the petitioner was allowed to remain on previous bail by the trial court so as to give him an opportunity to approach this court. Stop. Issue notice to the respondents. Since Mr. K.K. Parashar, learned additional public prosecutor, has
Question
appeared
number
for respondent number 1. No formal notice need to be issued to respondent number 1. Stop. However, as regards respondent number 2 is concerned, the petitioners shall take steps for issuance of notice upon the said respondents by registered post with AD, as well as by usual mode within 7 days of this order, returnable after 4 weeks. Stop. Let the records of the trial court as well as first appellate court be called for registry to take steps for requisitioning the aforesaid records. In the meanwhile, considering the fact that only 6-month sentence has been imposed on the petitioners during the pendency of this criminal revision petition, the operation of the execution of sentence imposed on the petitioners shall remain shall be kept in abeyance, and the petitioners then are allowed to remain on previous bail granted by the trial court, least accordingly after 4 weeks.
Obliged.
May I please, Your Lordship? I missed my item number, production list, item number 1.
1, no?
Yes.
May I please, Your Lordship? regular bail application lordship, as on the behind the bar lordship 62 days lordship. Vernacular original FIR page number 14 lordship.
What is the statutory period?
DAP is there,
DOP is there.
180 days.
Okay, we'll call for the case diary. Heard Mr. D. Sutia, learned counsel for the petitioner. Also heard Mr. K. K. Parashar, learned additional public prosecutor. Call for the case diary. Let this case be listed on 15th of September. Yes.
May I please, the Lordship? Lordship, hearing this case, Lordship, we are seeking bail on two grounds, Lordship. One is, Lordship, procedural requirement, Lordship, not complied, Vihan Kumar, Lordship, section 47. And the other ground, Lordship, regarding the definition of the seized contraband, I will come into the latter part, Lordship, into that second ground, Lordship. First, Lordship, that 47 BNSS, Lordship, that one bail application, Lordship, passed this bail application, Lordship, bail application number 629 Sakib Chaudhary, Lordship. I have supplied the copy, Lordship.
Now, what is your case?
Lordship, in my case, Lordship, 511 kg of suspected ganja, Lordship, was recovered, Lordship, from a house, Lordship, abandoned house from the premises of the accused, Lordship. Thereafter, Lordship, he surrendered, Lordship, before.
From your residence, from your.
From my residence, Lordship. Residence means, Lordship, abandoned house. That is, Lordship, separate from my dwelling house. It's an open house, actually, Lordship. In village area, Lordship, is some hay house, Lordship. Open house. From that house, Lordship, some these contraband were recovered, Lordship.
Thereafter?
Thereafter, Lordship, my both husband and wife was not present in the house, Lordship. So later on, Lordship, when NCB visited and recovered those items from that hay house, Lordship, thereafter, after 2 days, Lordship, I was called for. Then I appeared before the NCB, Lordship, and thereafter I was arrested, Lordship. And as on that, Lordship, almost 1 year I am behind the bar, Lordship. So basically, my grounds is under 47, Lordship, 47, and Lordship, and other one is, Lordship, that regarding definition of seized contraband.
No, what 47, what you want to say?
Lordship, 47, Lordship, notice was served, Lordship, that's mere simple notice, Lordship, no grounds of arrest were there, Lordship. So, Lordship, I'm relying on one order, Lordship, which is passed by your Lordship.
No, you rely later on.
Lordship.
First, make your submission. To fortify your submission, you can rely on the judgment.
Lordship.
But you have to make submission.
I'm coming into the Lordship. Lordship, in the IA, Lordship, which was filed, Lordship, in that IA, Lordship will come to page number 71. 71A, Lordship.
What is this?
Lordship, one IA was filed in the later period, Lordship. Final complaint, it is actually final complaint, Lordship. Page number 71A. Just after the page number 71, Lordship.
Yes.
That is, Lordship, notice under section 47 of BNSS, Lordship.
Yes.
No grounds of arrest is there, Lordship, only mere disclosure of, Lordship, section and this offense, Lordship, seized contraband.
No, why are you saying so? It is specifically mentioned that 511 kgs of ganja were recovered from your possession.
That is there, Lordship, but grounds of arrest is.
What is grounds of arrest?
Grounds of arrest, Lordship, if I come to the order, Lordship, of that order, Lordship, Sakib Chaudhary, Lordship, I have placed before the Lordship. Para number 27, Lordship.
What it says?
It says, Lordship, it was passed by your Lordship in the Mary, Lordship, para number 27.
Yes, what it says?
in the instant case, except the fact that the petitioner was served with the notice under section 47 of BNSS 2023, the prosecution side has not been able to show anything to satisfy the court that the grounds of arrest of the petitioner in this case were communicated to him as already discussed herein above. The notice under section 47 BNSS 23 served on the present petitioner only contains the information regarding his arrest in connection with the so-and-so, and the penal provisions involved in the case.
Yes, but this, in your case, it is different.
Lordship,
In your,
grounds of arrest are missing, Lordship.
what do you mean by grounds of
Grounds
arrest?
of arrest means, Lordship, grounds, Lordship, where, Lordship, that my involvement, the point,
So it says that it was found from your possession.
no detailed discussion.
What
Lordship.
details, what more details would be necessary?
Details, Lordship, in the sense, Lordship, I first thing, this way, it was not recovered from my possession. It was from my premises only, Lordship. Later on, I was apprehended, Lordship, when I surrendered, I went to their office, Lordship.
Okay, okay. So what is your next submission?
So next submission is regarding, Lordship, definition of the seized contraband, Lordship. Though it is suspected ganja, Lordship, Lordship, as per definition of section 2, Lordship, two subclause 3B, Lordship.
Yes.
Ganja, that is the flowering or fruiting tops of the cannabis plant, excluding the seeds and leaves, were not accompanied by the tops, by whatever name they may be known or designated. So, Lordship, those contraband which were seized from my premises, Lordship, those were not, Lordship, flowering and fruiting tops were missing there, Lordship, only green leaves, Lordship, which is admittedly accepted by NCB, Lordship.
Where?
Lordship, I have flag mark in the IA, Lordship, as well in the PCR also, Lordship, it is available. In the IA, Lordship, in the IA, I have mentioned the green leafy
Page.
Lordship. One is, Lordship, page number.
Where is the FSL report? What FSL report?
FSL shows positive, Lordship, that regarding those positive or negative, Lordship, that is a disputed thing, Lordship, because without flowering and fruiting tops also it will show positive, Lordship. So here matter is, Lordship, whether it was.
How, why are you saying so that
Lordship,
without
that is
flowering?
why I'm relying on some orders and judgments, Lordship. I have placed before you, Lordship. I will come into that, Lordship. Before that, Lordship, I'm page number 24 onward, Lordship. Page number 24 to
24 of?
IA, Lordship. That is the final complaint, Lordship.
No, what you want me to see?
Lordship, in the Lordship, final complaint, Lordship will see serial number 3, Lordship.
Page?
Even page number 20, from 24 to 29, all are.
Which page
Lordship,
should I
number
see?
24. Lordship will come to, at this moment, Lordship will come to page number 24. Dear Lordship will come to point number 3, Lordship. In the right side, Lordship, ganja cannabis sample envelope marked as so-and-so and weighted 24 grams contained dried green leafy material.
Yes.
Now, Lordship, we are continuing, and again, Lordship will come to page number 30, Lordship. Lordship will come to page number 30. Here again, they have mentioned that green leafy material. Page number 30.
Yes, it would be verified only during forensic examination whether that green leafy material contains fruiting tops or not.
forensic report is there, Lordship. It shows positive content, Lordship. But there was no fruiting and flowering top, Lordship. It's only a green leafy material, nothing else, Lordship. That is why, Lordship, I have relied some orders, Lordship, almost 4 or 5 high courts, from almost 4 or 5 high courts order, Lordship.
Okay, let us see.
Then, Lordship, again, they have in page number 21, sorry, 31, Lordship. Page number 31, that is inventory, Lordship. In the inventory, Lordship, they have mentioned that dark green leafy material. Page number 31. Page number 31, they have mentioned that dry, dark, green leafy material believed to be ganja.
Yes. Yes.
So, Lordship, now I'm coming to the Lordship. Orders, Lordship. I have supplied the blue color, 2 sets of orders, Lordship. One is so first I'm relying on some on Hasubhai Kamabhai Thakkar, Lordship.
Yes.
In that order, Lordship, the definition was discussed, Lordship. Definition 2(3)(b) of NDPS, Lordship, discussed. Para number 3, Lordship.
Yes, there is no dispute about the definition.
Right, Lordship. That dear Lordship, the second line, Lordship, ganja seeds as it's already in the NDPS Bayer Act, Lordship, that seeds and leaves. Definition 2(3) subclause B, Lordship, that excluding seeds and leaves, Lordship,
Okay.
without flowering and fruiting tops. So that was from, Lordship, on the Apex Code, Lordship. The next one is, Lordship, next order was from, Lordship, High Court
No,
of
no,
Karnataka.
but in this case, petitioner had supplied ganja seeds.
Exactly, Lordship. Even in the Bayer Act also, Lordship, seeds and leaves. In our case also, Lordship, it is leaves,
Not leaves only, leafy material.
leafy materials. Indirectly, Lordship, it leaves without
Now,
fruiting
whether
and flowering
leafy
top.
material contains fruiting tops or not,
Lordship,
that can be ascertained only in forensic examination.
Exactly, Lordship. In forensic, no mention about fruiting or flowering top, number 1. And even in their entire record, Lordship, it's a voluminous record. Nowhere they have mentioned that fruiting or flowering tops they recovered, Lordship. Only the dark green leafy materials. Not a single whisper on, Lordship, fruiting or flowering top. So, Lordship, the next one is, Lordship, from the Karnataka High Court, Lordship. That is Roshan Kumar Mishra, Lordship. Roshan Kumar Mishra.
Yes.
So, Lordship, page number 5, Lordship. I have highlighted some other cases, Lordship, that Madhurkar versus the state of Maharashtra. Then, Lordship, again, Arjun Singh. All these, Lordship, cases discuss about this part, Lordship, that whether leaves without flowering or fruiting top can be cannabis or not, Lordship. Now, Lordship will come to the next one is, Lordship, Jangir Singh, Lordship. Page number 3.
Yes.
The last paragraph, Lordship, may I read, Lordship? The cannabis plant is defined under section 2(4) of the NDPS Act, which means any plant of genus cannabis. It is also relevant to mention here that bhang cannabis plants are of two kinds known as male and female. A female cannabis plant is called pistillate plants, whereas male plants is identified by short auxiliary dropping particles. Female flowering tops coated with resin are ganja, whereas fruiting leaves are called bhang. Now, Lordship, according to Moody's Medical Jurisprudence and Toxicology, 21st edition, 1988, section 2, toxicology chapter, page so and so, bhang, siddhi, patti are cannabis sativa consists of dried leaves and fruiting shoots, whereas ganja has rusty green color, a characteristic color, and consists of flowering or fruiting tops of the female plant coated with resin. So, Lordship, it's very clear, Lordship, that in our case also, Lordship, it was only dry leafy material, no fruiting or flowering tops were recovered from the possession, from the, Lordship, recovery, Lordship.
Okay.
That in the same order, Lordship, page number 5. Page number 5. A perusal of the above definition of cannabis hemp would reveal that cannabis means saras, ganja, or any mixture of saras or ganja. So far as ganja is concerned, it is the flowering or fruiting tops of the cannabis plant, excluding the seeds and leaves, when not accompanied by the tops by whatever name they may be known or designated. What is relevant to note is that the legislature has consciously excluded the seeds and leaves of cannabis plant when not accompanied by the tops. In the next page also, Lordship, it is apparent from the aforesaid definition that bhang is excluded from the operation of NDPS Act. So here my contention is that, Lordship, the recovered, Lordship, contraband was bhang only. That was not cannabis or ganja, Lordship.
Okay. Where is the FSL report?
FSL report is, Lordship. Just a moment, Lordship. Lordship, page number 135. Yes, the result of the is 137, Lordship. From 135 onwards, it's 137. Lordship, there was no whisper on, Lordship, fruiting or flowering tops, Lordship.
But result says that it is samples of ganja,
Definitely,
not
Lordship,
cannabis.
in all cases, Lordship, what I have cited, Lordship, in all cases, it will show positive.
Positive for ganja.
Positive for ganja, Lordship,
Why?
cannabis. But Lordship,
Ganja has a specific definition, fruiting tops and flowering and fruiting tops. Unless the FSL finds those flowering and fruiting tops, it cannot report as ganja.
that even if, Lordship, without fruiting or flowering tops also, Lordship, leaves will also show the same, Lordship, result. But what, Lordship, even the apex code also, Lordship, in case of seeds and leaves, Lordship, it is different, Lordship, without flowering or fruiting tops, Lordship. That is clear, Lordship. Regarding that point, Lordship, there is no dispute that, Lordship, it will show positive or negative. It will always show positive result, Lordship, in the forensic. But, Lordship, the question is that, Lordship, whether it was fruiting or flowering top was there or not, Lordship. That is the question, Lordship. Lordship, in other cases, Lordship, like heroin, like brown sugar, in that case, Lordship, the mixer, then Michael has those judgments will come, Lordship, that mixture of that, Lordship, contraband. But in ganja, Lordship, it is very clear that, Lordship, fruiting or if there is fruiting or flowering top, then it is, Lordship, under NDPS Act. Otherwise, Lordship, it is bhang and not covered by NDPS, Lordship.
Okay. Yes, Mr. Yeah.
What's it, report clearly says that it was a ganja. What's it, page 67 of the additional letter. Repeat question number 9, 8 and 7, 9.
Page 60.
Page 67. The statement of the accused.
Yes.
Page 67, question number 7. do you recognize the gunny bag, SDFC bag containing suspected ganja that have been recovered from your residential premises, kept in custody of seizing officer? Are these samples bag and check it? Yes, yes, sir. I do recognize all 41 bags, gunny bags, which have been kept in custody of the seizing officer. These are the sample bags that which I have stocked at my house, and also I have checked its contents and confirmed that all these bags containing ganja, just the way I stored in my house. Then question number 9 also. Do you know about the content of 41 gunny bags that has been secreted inside your residence house? Yes, I know that 41 bags numbers of gunny bag containing ganja inside it due to the reasons that I saw officers conducting search inside my premises. I somehow managed to escape from the spot. He himself admitted that the content of the 41 bags which is seized, this contains gaja. And report lordship says, the next page lordship. Question number 11. How do you come to possession of ganja? Do you know that it is a narcotic drug restricted and controlled under NDPS Act, and possession of the same is punishable in the crime? Yes, I being a farmer and a PT worker was reeling under the financial strain. I was really getting difficult for me to look after my family and household needs. Besides, both my children have grown up. My elder daughter, who has been completed her BA and is of marriageable age. Further, my young son, who is yet to establish himself, is financially dependent upon me. In such situation, I was looking for some means where I could earn a faster income. It is during such time I met some people from Meghalaya. Sir, our places is not that of far from Meghalaya, and that started bordering is hardly 6 kilometers from my house. So I met many people from Meghalaya who came to our village and also adjacent towns, market and various work as well as for trade. Sir, it is the matter that I have happened to meet one person whom I used to call Rabhada. His actual name is not known to me, but he is resident of Meghalaya and is married to Khasi lady of Meghalaya itself. Sir, that sir, this person, that is Rabhada, has been dealing in ganja for quite some time. One day, around 10-15 days back, during our meeting, I was just discussing about my financial status and economic hardship. It is then he gave me proposal of dealing in ganja cannabis. He offered me that if I could stock a sizable amount of ganja in my custody, it will be very much conducive for him to make a good deal with the various prospective buyers, especially from Northeast India. He told me that the buyers who have come from Northeast India pay a good price for ganja, and that is he could stock a sizable quantity of ganja at my place, which is at a strategic location, having a good and road connectivity with the nearby towns, and also with national highway. Then both of us could earn a
Yes, Mr. Kyan.
So this narrative
Apart from his submission, the counsel for petitioner is saying that in your final complaint, you have mentioned about only leafy
No,
material.
lots of pleased to see. The page, we have mentioned about, okay, there are two statements. Initially, it was, page 16, paragraph 7. Page 16
16
of the bail application. Paragraph 7. That, sir, the officer then carried out a test of recovered substance.
bail application or additional affidavit.
Bail application. Page 16.
Yes.
Paragraph 7.
that, sir, the officer then carried out test of recovered substance by taking out some samples randomly from the SDPE gunny bags, numbers so and so, also from so and so, in presence of the Panchaj as well as Mrs. Swapna Das, with the official narcotic drug test kit being carried by them. The testing of the recovered substance gave positive test of color brown, which clearly indicates test positive from the ganja cannabis. This is initially when it was seized. Then it was sent to, sample was sent to the FSL. Report is Lordship has seen. This give positive of so and so. And Lordship, this is a matter of trial. He can cross-examine or the FSL officer Lordship who has submitted the report. Regarding Lordship, regarding section 47 notice, Lordship has seen that everything is mentioned there. And Lordship, the accused was arrested on 5/9/24. Then final complaint was filed on 28/2/2025. Charge framed on 25/4. Two witnesses have been examined so far. One is complete, he was discharged. Then the chief of the PW2 has completed cross year. It will be cross by son, the accused person.
How many witnesses are there?
10 witnesses.
So Lordship, regarding witness part, Lordship, it is not true that two already examined. Out of two, Lordship, one is Lordship, that Caesar officer.
What I have submitted, the one has been completed, second is only chief has been completed now. He has to be cross-examined by the accused counsel of the accused.
Lordship, what happened regarding Caesar officer, Lordship? The Caesar officer appeared, Lordship, and was examined. During cross-examination, Lordship, it was found by the trial judge, Lordship, that they have submitted the all the original documents to the court, but Lordship, the inventory, the Caesar list, that was Xerox copy only, Lordship. Original copy is missing. Therefore, Lordship, the cross-examination was stopped at that moment, Lordship, and directed to bring that original one, and date has been fixed in October month, Lordship. So regarding, Lordship, examination of the witness, Lordship, Caesar officer is incomplete, and the other one, Lordship.
Okay.
Yeah. And regarding, Lordship, that points, Lordship, raised by learned senior, Lordship, that confessional statement. In that regard, Lordship, Tufan Singh will come, because Lordship, confessional statement also, Lordship, it shows nowhere it is mentioned that fruiting or flowering tops were there, Lordship.
Okay. Heard, Mr. What is your name?
M. Rahman.
M. Rahman, learned counsel for the petitioner. Also heard Mr. SCKR, learned standing counsel NCB.
Lordship, it's a matter related to custom law.
Learned standing counsel customs. This application under section 483 of BNSS 2023 has been filed by the petitioner Bipul Kumar Das, alias Bipul Das, who has been detained behind the bars since 5/9/2024, within bracket for last more than 11 months, in bracket close, in connection with customs case number 01/CL/NARC/AS/GAU/2024-2025, dated 4/9/2024, under section 8C/20B2C/29/60 of the NDPS Act 1985. The gist of accusation in this case is that on on 4/9/2024, at about 11:45 hours, the officer of Anti-Smuggling Unit, Guwahati Customs Divisions, had received an information through reliable sources that one person, namely Vipul Kumar Das, within bracket present petitioner, had stocked narcotic substance believed to be ganja at the backyard of his house. Stop. On receipt of the said information, a team of custom officials was formed and they rushed to the house of the present petitioner. During search operation, the petitioner was not there. However, his wife, Mrs. Swapna Das, was found there. And during search, numbers of gunny bags were found containing suspected ganja therein. On weighing the ganja, the weight of the suspected contraband was found to be 511.175 kilograms. Stop. Learned counsel for the petitioner has submitted that the petitioner has approached this court seeking bail mainly on two counts. Stop. Firstly, that the petitioner was not informed, not communicated about the grounds of his arrest at the time of his arrest. And secondly, the contraband which has been seized in this case does not fall within the definition of ganja as provided in section 2.
2(3) B. 2(3) B.
2 within bracket Roman 3 within bracket B of the NDPS Act. Stop. Learned counsel for the petitioner has submitted that though at the time of his arrest, the petitioner was served with a notice under section 47 of the BNSS. However, it did not contain any grounds of arrest or basic reasons which necessitated his arrest in this case. He submits that it only contained the case number as well as penal provision in which the petitioner has been arrested. He therefore submits that there has been violation of the constitutional mandate of communicating grounds of arrest at the time of his arrest. And on that count, he is entitled to get, on that count, it is submitted that the petitioner is entitled to get bail in this case. The learned counsel for the petitioner has cited the ruling of Apex Court in the case of Pankaj Vihan Kumar. What is the citation? Vihan Kumar versus State of Haryana and another reported in 2025 5 SCC 799. Stop. Learned counsel for the petitioner has also submitted that the contraband seized in this case is not ganja, as nowhere in the final complaint there is any mention that the seized contraband were the flowering of the fruiting tops of cannabis plant. Rather, what was seized is the leafy materials only, green leafy materials only. In support of his submission, the petitioner has brought to the notice of this court the test memo accompanying the final complaint filed by the NCB, wherein the column number 3, where alleged description of drug has to be given, it has been mentioned that within inverted comma, containing dried green leafy materials. Learned counsel for the petitioner submits that dried, the leafy material minus fruiting top would fall within the definition of bhang and not ganja, and would be outside the scope of NDPS Act. In support of his submission, he has cited a ruling of the Apex Court in the case of Hasubhai Kamabhai Thakur versus State of Gujarat, reported in 2023 Live Law within bracket SC 354. He has also cited another ruling of the High Court of Karnataka in Roshan Kumar Mishra versus State of Karnataka within bracket criminal petition number 6611 /2022. To emphasize his submission that bhang is quite different from ganja as defined under the NDPS Act. Stop. He therefore submits that the petitioner is entitled to get bail in this case. On the other hand, Mr. SCKL, learned Standing Counsel NCB, has vehemently opposed the grant of bail to the petitioner in this case on the ground that the quantity of contraband seized in this case is of commercial quantity, and therefore embargo of section 37 of the NDPS Act is applicable to this case. He submits that the notice under section 47 of BNSS, which was served on the petitioner on the date of his arrest, that is 5/9/2024, it has been clearly stated that the petitioner has been found involved in possession of 511.175 kgs of suspected ganja, which is a narcotic substance included in NDPS Act. He submits that apart from the aforesaid information, the penal provisions and the market value of the seized contraband was also mentioned in the notice under section 47 of BNSS. He also submits that bare perusal of the said notice would reveal that as to why the petitioner was required to be arrested in this case. He submits that the grounds of arrest are very well stated in the said notice, and therefore he opposes this submission of the learned counsel for the petitioner that constitutional mandate has been violated in this case. Learned counsel for the Learned Standing Counsel for the NCB has also submitted that at the time of seizure of the contraband from the premises of the petitioner, drug testing kit was the seized contraband was tested by utilizing drug testing kit, and the result of the drug testing kit, result of the said test was shown to be positive for ganja. He further submits that even the forensic report of the samples sent to forensic laboratory clearly shows that the samples are of ganja. He therefore submits that in view of categorical finding in the report of the forensic laboratory, there remains no doubt that the seized contraband is ganja and not bhang as submitted by learned counsel for the petitioner. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the records of this case. The petitioner has sought, as discussed, as stated earlier, the petitioner has sought bail in this case mainly on two grounds, that is non-communication of grounds of arrest in writing, as well as the fact that the contraband is not ganja. Let us examine both these grounds. On perusal of the notice under section 47 of BNSS, which was served on the petitioner on the date of his arrest by the arresting authority, it appears that it clearly indicates that the petitioner was found involved in possession of possession of 511.17 kgs of suspected ganja, which was seized in this case. Apart from the aforesaid information, the total value of the seized contraband as well as penal provisions involved in this case were also mentioned in the notice. The requirement under Article 22(1) of the Constitution of India as well as under section 47 of the BNSS is that grounds of arrest should be communicated to an arrestee as soon as possible after his arrest. In this case, stop. This court is of considered opinion that this is not a case where no grounds of arrest were furnished to the petitioner, or that the section 47 notice which was served on him is devoid of any ground of arrest. It, in the considered opinion of this court, gives sufficient notice of the accusation made against the petitioner so as to intimate him as to why he has been arrested. Stop. Therefore, now this court is of the considered opinion that for the reasons mentioned, reasons discussed in the foregoing paragraphs, this court is unable to agree with the contention of the learned counsel for the petitioner that no grounds of arrest were furnished to him. Let us now discuss the second contention raised by the petitioner. Stop. It is apparent from the final complaint lodged by the NCB that the contraband which was seized in this case was described as containing dried green leafy material believed to be ganja. Stop. It is also true that ganja has been defined in section 2 within bracket 3 within bracket small b as the flowering of fruiting tops of cannabis plant, excluding the seeds and leaves when not accompanied by the tops. Stop. In this case, it appears that the substance, the contraband which was seized was green leafy material. The question is now as to whether that green leafy material contained flowering of fruiting tops or not. If we peruse the forensic laboratory report, it gives the result of examination as positive for samples of ganja. Stop. Apart from that, it also mentions clearly that characteristic microscopic features of ganja were consistently observed. Stop. In view of the report of the forensic laboratory, which indicating that characteristic microscopic features of ganja were observed consistently in the samples sent in this case, there remains no doubt, at least at this stage, prima facie, there remains no doubt, Katideo. Prima facie, it appears that the seized contraband is ganja. And therefore, this court is also unable to persuade itself with the submissions made by learned counsel for the petitioner that the seized contraband falls within the does not fall within the definition of ganja, and it is only bhang. Stop. In view of above submissions, in view of the above discussions, this court, in view of the above discussion, as well as considering the fact that the quantity of contraband seized in this case is commercial quantity, and embargo of section 37 is applicable to this case. The prayer for bail is rejected in this case.
Obliged, Lordship.
25.
Yes.
Wait, please, Your Lord. Here the petitioner was arrested, my lord, on 07/12/24, my lord. That your lordship will find at page 21, my lord. With regard to, my lord, NDPS case, my lord. Page 21 is the, my lord, forwarding report, my lord. So, my lord, the investigating agency, after completion of the investigation, had filed the charge sheet, my lord, on 4/6/25. Arrested on 07/12/24. Charge sheet filed on 04/06/25. And my lord, in the charge sheet, my lord, 10 numbers of listed
4/6.
4/6, my lord,
25 or 24?
25. 04/06/25 charge sheet.
And you were arrested on?
07/12/24.
Yes. Now, what is your case?
And in the charge sheet, my lord, 10 numbers of witnesses have been cited, my lord. And until that, none of the witnesses have been accepted. None of the witnesses. Now, my lord, lordship may come turn to page 68, my lord. This is the notice under section 47 of the BNSS. Here, my lord, only, my lord, it is stated, you are hereby informed that you are arrested in connection with the above reference case and violation of the NDPS Act in connection of the seizure of so-and-so of opium. The case is non-bailable, so you will be produced before the Honorable Jurisdictional Court. You may submit petition, my lord. Whether it suffice, my lord, the grounds, my lord. Because, my lord, one line has to be added, my lord, that you are arrested in connection of seizure of so-and-so, which is a narcotic substance included in the NDPS Act.
No. Even if that line is not added,
My lord.
from where this seizure has been made, that has to be indicated,
Yes, ma'am.
that it was seized from your possession.
My lord. There is nothing, my lord. You are arrested in connection with the above reference case in violation of an NDPS Act in connection of seizure of so-and-so. So before your lordship, my lord, there are two petitioner, my lord. Next page also same, my lord. This is to the, my lord, petitioner number 2, my lord, Isharam, my lord. Now your lordship will turn to, my lord, page 70, my lord, 70, my lord. And page 70. My lord. $36. 35.
70.
70, man. 7-0, my lord, it's a memorandum of arrest, my lord. Here your lordship will find, my lord, signature with the date, name and designation, my lord. The person who has arrested, my lord, that intelligence officer, his signature is there, my lord. Below your lordship has seen, my lord. On the left side, my lord, it has been given to Manak Ram, son of so-and-so, my lord, and he has put his signature, my lord. So in the FIR or the first initial complaint, my lord, all the allegations, my lord, leveled against the petitioner is by this intelligence officer. So if your lordship comes to the, my lord, section 36 of the BNSS, my lord, for a once, my lord. Section 36, my lord, which is earlier, my lord, 41B of the CRPC. my lord.
Yes.
May I read, my lord? Procedure of arrest and duties of officer making arrest. Every police officer while making an arrest shall A, bear an accurate, visible and clear identification of his name, which facilitate easy identification. Now B1, my lord, which is very important, my lord. Prepare a memorandum of arrest, which shall be attested by at least one witness who is a member of the family of the person arrested or a respectable member of the locality where the arrest is made. So in the instant case, my lord, by going through the memorandum of arrest at page 70 and 71, my lord, no one has attested the same, my lord, no witness. Because these allegations are leveled by them, my lord. So it has to be attested by one of the witness, my lord. No signature of any attested witness. And now, my lord, if your lordship,
What will happen if there is no?
because the allegation is leveled by them, my lord. Well, if I went out in the evening from the afternoon from the court, my lord, carrying my bag, my lord, if some police personnel comes and says, my lord, we have found some ganjas or some NDPS contraband in your bag. So that has to be, there has to be a witness, my lord. Yes, something has been found. So the Act says, my lord, it is a respectable person of the locality. So if a case, my lord, under 302 or any case under IPC, my lord, the police may come to my home and arrest me, my lord. And in this case, my lord, my family member will put a signature on the arrest memo. But in the instant case, my lord, he has been arrested. And the law provides, my lord, it should be countersigned by a witness. There is no signature of the witness, my lord. Now, my lord, the Article 22 of the Constitution, my lord, comes, my lord. No person shall be deprived of his life or personal liberty except according to the procedure established by law. This is the law, my lord. This has to be, my lord, followed by. And here also, my
But the
lord,
question is this mandatory?
yes, it is mandatory.
What is the
Mandatory. Why, my lord?
consequences of lapse?
My lord, mandatory, my lord, your lordship will find, my lord, section 62 of the same BNSS, my lord. Section 62, my lord, of the BNSS, my lord. May I read, my lord?
Yes.
Arrest to be made strictly according to Sanhita, my lord. No arrest shall be made except in accordance with the provision of this Sanhita or any other law for the time being in force providing for arrest. My lord. It's there, my lord. And the other ground, my lord, that section 48, my lord. Section 48 of the BNSS, my lord. And I have gone through the record, my lord, that notice was not served. Okay. 48 notice was not served. Well, so far, my submission is threefold, my lord. 47, it does not suffice the ground. Number 2, my lord.
What is the contraband?
Contraband is 21.600 kilos of, my lord, opium.
From where it was recovered?
My lord, in a Naka checking, my lord, according to them, in a Naka checking, my lord, in Nazira Khat, my lord, toll gate, my lord,
From a vehicle.
from vehicle.
You were in that vehicle?
Yes. What? Nazira Khat, my lord. So I rely upon the Vihan Kumar's case, my lord. 48 notice, my lord, keeping for the time being, my lord, 47 not, my lord. 48 notice not to have been served, my lord.
Okay, anything else?
48 notice is not there from the record I have checked. Only, my lord, your lordship will see, my lord, I have to point out, my lord, page 70, my lord. Page 70, my lord. Below there is a writing in Hindi, my lord, Hindi, my lord. मैंने
अपनी गिरफ्तारी की सूचना घर पे अपनी पत्नी को इस नंबर पर सूचना दे दी.
Although I have written, my lord, in the arrest memo that the information regarding my arrest should be given to my wife, my lord. That is there in Hindi, my lord. But that 48 notice is not available. It is not served, my lord.
Yes.
Lordship, many ground has been rushed for seeking bail. Some dates are important. My learned friend has submitted dates. Dates are correct. Lordship, he was arrested on 7/12/24 from toll gate. Lordship has seen the notice. Lordship, we have landmarked the 48 notice in the record.
48 notice.
It is there. 47 he has annexed with the application, but 48 is in the record.
Where? You have gone through Mr. Datta Shri Darshan's
Yes, ma'am.
judgment.
Well, I am ready to reply
Reply.
to that. I am ready to reply to that. I have come prepared. If my learned friend raises that point, my lord, I will reply. ma'am. I think my friend has gone through it, my lord.
48 is not there.
48 is not.
But there is an indication that you have informed your wife
No, no,
over telephone.
I have, that means, my lord, designated person, my lord. I have stated. This is number pe phone kijiye. Is number. I have given the information of my wife. They could have easily supplied to the concerned police station, through the concerned police station.
Record is not completely sent by the MHM.
67. It's not there, madam.
The record it is not there.
It's not there.
Okay. Yes, you may make other submission.
Let's see, page 11
Record.
of the bail application. Panchnama.
Yes. Yes,
Also, it contains the signature of both the accused as well as the witness as well as the IO.
Caesar,
Yes, the Panchanama dated 6/12/24 on the day of. When the notice was under section 47 was served on him.
but the requirement in under 36 is,
What's it?
under 36 of the BNSS. The requirement is
Six years. 36.
36.
in the memorandum of arrest you have to take. It is very clear that in the memorandum of arrest you have to take signatures of the witness.
What's it? This point was raised before this honorable court, and this is the order of passed by this.
What has been, you can take this.
Lordship, yes. And Lordship, 48 notice was served, I informed on the IO. He said that it was complied with, probably record has not come. Lordship, we will allow some time, I will probably prefer.
Okay, we'll grant you time, but regarding compliance of 36,
No compulsion.
if you need time, we can grant you time.
Lordship, day after tomorrow.
Yes, Mr. Datta, day after tomorrow.
I have
Heard Mr. N.J. Datta, learned counsel for the petitioner. Also heard Mr. S.C.K. learned standing counsel on learned standing counsel NCB. Learned counsel for the petitioner has submitted that he is seeking, the petitioner is seeking bail in this case mainly on 3 grounds, namely, number 1, he was not informed about grounds of arrest in writing as required under law in the notice served on him under section 47 of the BNSS. Secondly, no notice under section 48 of BNSS was served on the relatives / friends / nominated persons of the petitioner. And thirdly, the arrest of the petitioner was not in accordance, strictly in accordance with the provisions of BNSS as required under section 61.
36.
Six-
36 B1
and 61.
and 60 and 60 and
Under section 61
yes,
of BNSS, read
62, madam.
62 BNSS. read with section 36 within bracket small b of the NDPS Act. Stop. Learned Standing Council NCB, on the other hand, submits that there has been no non-compliance of the statutory or constitutional requirement in this case. He submits that the records of this case, he could not find notice under section 48. He could not find a copy of notice under section 48 in the records of this case. However, he has been informed by the investigating officer that said notice has been served on the relatives of the petitioner, and therefore he seeks 2 days' time to produce a copy of that notice before this court. The prayer is allowed. Let this matter be listed. When? Day after tomorrow is 28/8.
I'm okay.
I'm not on merit in this case, located on length of detention 57 days, petitioner behind the bar located in that this case that FIR name the accused located already released by this honorable court on.
You have to be
13.
louder.
I'm not on merit in this case, Lordship. On the
Mic
length
come
of
karo.
detention, Lordship.
He's not on merit. He's not paying on merit.
On length of
length
detention.
of detention, Lordship. 57 days behind the bar, 60 days is the mandate. That's to be.
What is the offense?
Offense Lordship in FIR page number 13. Some persons.
My lord, in the
Arrested
forwarding
for the-
report itself, it says, my lord. Page 16, grounds of arrest, serial number 4. Suspicion fund movement within the short span of time and an amount of rupees 84,18,038 illegally credited to the aforesaid account from unidentified source. Subsequently, nearly equivalent amount were debited. So, matlab, several persons, matlab, some few were released on bail. Otherwise, matlab,
What is your role? No, length of detention, then you have to wait for 3 more
Nothing.
days.
My rule is not there, Lordship. With this amount which I've mentioned, Lordship, someone deposited my account.
We list it after 3 days if you are pressing for length of detention.
My rule
Other,
is not there in this.
otherwise,
section of
we'll
the
reject it.
This amount was deposited to my account, Lordship. After some time, Lordship, they have automatically withdrawn the debited.
there are other persons also there, matlab,
Proactive is
Oh,
already released from bail.
no.
organized crime.
Heard Mr. ABT Hall, learned counsel for the petitioner. Also heard Mr. KK Parashar, learned
Further custodial interrogation is required, Lordship, since 57
Learned.
days behind the bar.
learned additional public prosecutor who has produced the case diary. Let this matter be listed
Friday?
on Friday. Friday then. Let the case diary be written till then. Yes.
Getting grounds of arrest. I requested some time to go to the records for the.
Yes,
It's not there.
it is not there. You have gone through that case,
Yes, recent one,
recent one.
302 case, also where the grounds of arrest were given at a later point of time. These have done. South Indian actors, yes.
Okay. Heard Mr. What is that?
Yes, yes.
Lord Mr.
Yes, Hussein.
S. Hussain, learned counsel for the petitioner. Also at Mr. B. Sharma, learned additional public prosecutor. This application under section 483 of VNSS has been filed by the petitioner, namely Nayan Chandra Nath, who has been detained behind the bars since 5/2/2024 in connection with Dhubri PS case number, in connection with special case number 447/2024 arising out of Dhubri PS case number 34/2024 under section 22C/29 of the NDPS Act 1985, presently pending before the Court of Learned, Additional District and Additional Session Judge Dhubri. The gist of accusation in this case is that on Four to 2024, one Kapil Chandra Das had lodged an FIR before the officer in charge of Dhubri Police Station, inter alia, alleging that an information was received through reliable sources that large quantity of contraband has been kept in the house of one Nayan Chandra Nath, within bracket present petitioner. Stop. On receipt of the said information, a police team was constituted and it proceeded to the house of the petitioner. Stop. The house of the petitioner was searched in presence of witnesses, and during search operation, hundred and 30 numbers of cough syrup bottles containing codeine phosphate, 240 numbers of tablets E1 Spas Plus capsules containing tramadol, and 140 numbers of tablets containing nitrazepam were recovered therefrom. Learned counsel for the petitioner has submitted that the petitioner has been languishing behind the bars since 5/2/2024. What is the status of the trial?
Evidence is test lordship.
How many witnesses have been examined?
As per lordship, LCR 3 witness has been done.
2024, and till date, only 3 prosecution witnesses have been examined. He submits that at the time of arrest of the petitioner, Putul record, arrest of the petitioner, no notice was served. Though notice under section 50 CRPC was served on him, however, it did not contain any grounds of arrest therein. Stop. He submits that it only contained the police station case number and the penal provisions involved in the case, and no basic facts were mentioned therein. He submits that there has been a violation of fundamental right of the petitioner guaranteed under Article 22(1) of the Constitution of India, as well as statutory requirement under section 50 of the CRPC. He submits that on that count only, the petitioner is entitled to get bail. In support of his submission, the petitioner has cited a ruling of the apex court in the case of Vihan Kumar versus State of Haryana and another, reported in 2025 5 SCC 799. Stop. On the other hand, learned additional public prosecutor Mr. B. Sharma has fairly conceded that though the notice under section 50 of CRPC was served on the petitioner, it does not contain the basic facts which necessitated the arrest of the petitioner in this case. Stop. As observed in the apex, observed by the apex court in the case of Vihan Kumar versus State of Haryana within bracket Supra. The non-compliance of the requirement of Article 22(1) vitiate the arrest of an accused. And such an arrestee would be entitled to get bail on that count only. Stop. Stop. I have considered. I have considered the submissions made by learned counsel for both sides and have gone through the records of this case, including the scanned copy of the case record of special case number 447/2024. Since apparently on perusal of the notice served on the petitioner under section 50 of CR Code of Criminal Procedure, it appears that it is devoid of any grounds of arrest and no basic facts which necessitated the arrest of the petitioner in the aforesaid case has been mentioned therein, comma. Mere serving a copy of notice under 650 on the petitioner without mentioning therein the grounds of arrest is a clear violation of the constitutional mandate provided under Article 22(1) of the Constitution of India. As stop. Therefore, comma, in view of the observations made by the apex court in the case of Vihan Kumar within bracket Supra, the petitioner is entitled to get bail on that count only. Stop. Accordingly, the petitioner is allowed to go on bail of rupees. What was the contraband?
Pop syrup, 30 numbers of cough
Okay,
syrup.
50,000 with one surety of like amount. Subject to the satisfaction of learned additional session judge to agree with following conditions, trial conditions. This bail application is accordingly disposed.
Met legal. Lordship, the petitioner has been arrested on 2nd of January 2025, Lordship, in connection with Tamarhat PS case number 2 of 2025, Lordship. Apart from 6 of POXO, Lordship, there are provision of 143 within bracket 3, 127, 2, 65 and 64 of the BNSS 25. Lordship, allegation is that
Yes,
the petitioner has committed rape upon the minor daughter of the informant. Lordship, but from the length of detention, Lordship, 47, 48 notice I have seen on the record, Lordship, there is no statement regarding grounds of arrest, nothing, only he is informed, Lordship. That too, those notices were not supplied to the petitioner, but I have seen on the record there is some impression. Lordship may kindly peruse 47 and 48 notice, Lordship. It is flag mark, Lordship. Lordship, the judgment is also here.
yes, what is it?
Lordship, judgment I have given, Lordship, paragraph 29, Lordship. In a similar situation, Lordship was pleased to hold that non-furnishing of grounds of arrest lead to
When you were arrested,
resulting the clear violation of the constitutional rights, as well as Lordship Bihan Kumar judgment.
when you were arrested,
Lordship, 2nd of January 2025. Lordship.
now what is the stage?
Lordship, evidence is going on. Informant, victim, as well as another is Lordship, 3 witnesses has been examined, Lordship. We have indicated, Lordship.
In the record, there are two,
Subsequently on 7-8, Lordship.
victim and father, informant.
Lordship, page 23 of my petition, Lordship. Jahanuddin examined on 7-8, Lordship. 7th of August, Lordship. And Lordship, the informant examined on 24/4/2025 and the victim examined on 7/4/2025.
Okay. So your submission is 47, 48 is violated.
Lordship.
That is,
Clearly, there is nothing, Lordship. I have seen that in the record.
yes, how will you overcome?
My lord, regarding that, he stated that it is not supplied, whereas thumb impression is there. If
Lordship,
thumb
that I
impression is there, my lord, it cannot be said that it is not supplied. Otherwise, yes, I have seen, my lord, the arrest memo also. Specific it is not there, but it was supplied. And in the merit also, my lord, 15 years old girl,
Learned Legal Aid Council appearing for the respondent number 2. This application under section 483 of BNSS has been filed by the petitioner, namely Jahanuddin Sheikh, who has been detained behind the bars since 2/1/2025 in connection with special POCSO case number 38/2025 under section 6 of the POCSO Act, read with section 140 within bracket 3/127 within bracket 2/65 within bracket 1/64 within bracket 2 within bracket M of BNS pending before the Court of London Special Judge POCSO. The gist of accusation in this case is that on 1/1/2024, the father of the petitioner, father of the victim girl, has lodged an FIR that on the night of 31/12/2024, when the informant woke up, he could not see her daughter he could not see his daughter in his house. And later on, in his house stop. It is further stated in the FIR that later on, the brother of the petitioner recovered her at Hatidura Bridge, and from there she was brought back. On inquiry, she informed that she went outside the house to attend the nature's call, and the petitioner grabbed her and took her to a nearby paddy field and raped her. So, learned counsel for the petitioner submits that there was a love affair between the petitioner and
Shiva, I am sorry, para number 3 of my petition, oh, you have an.
you have stated
Yes.
love
Para
affair
3.
between the petitioner and the victim girl. He also submits that in this case, though notice under section 47 of the BNSS was served on him, however, no grounds of arrest is mentioned therein. He submits that there has been violation of the constitutional right, fundamental rights of the petitioner guaranteed to him under Article 22(1) of the Constitution of India. And on that count alone, he may be allowed to go on bail. In support of his submission, he has cited a ruling of the apex court in the case of Bihan Kumar versus State of Haryana and another reported in 2025 5 SAC 799. He further submits that in the meanwhile, the petitioner, the informant, and one independent witness has already been examined by the trial court. He also submits that the petitioner is ready to cooperate in trial and therefore he may be allowed to go on bail. On the other hand, learned additional public prosecutor Mr. K.K. Parashar has vehemently opposed the grant of bail to the petitioner on the ground that the victim girl in her statement recorded under section 183 of BNSS, as well as while deposing as PW1, before the trial court, has also implicated the petitioner. He, however, fairly submits that in notice under section 47, grounds of arrest were not mentioned, though the thumb impression of the petitioner appears there. Stop. Learned legal aid counsel, Ms. Bhattacharya, Chakravarti, has also opposed the grant of bail to the petitioner as the trial is going on and there are some more independent witnesses to be examined. I have considered the submissions made by learned counsel for both sides and have gone through the records of this case, including the scanned copy of the case record of special case number 38/2025. Stop. The petitioner in this case is a young boy of 21 years of age. Stop. It also appears that the victim girl and the informant have already been examined as prosecution witnesses. However, these facts do not entitle him to get bail. Stop. What makes petitioner entitled to get bail is that in this case, the constitutional mandate of Article 22(1) of the Constitution of India, as well as statutory requirement of Section 47 of BNSS have not been followed by the arresting authority, which itself entitles the petitioner to get bail on that count. On perusal of the notice under Section 47, which was served on the petitioner, it appears that it only give intimation to the petitioner regarding the fact of his arrest in connection with Amarhat PS case number 2/2025. No other basic facts which necessitated his arrest has been mentioned therein. Stop. The apex court in the case of Bihan Kumar versus State of Haryana and another within bracket Supra has observed that at the time of arrest of an arrestee, the arresting authority is required to communicate the grounds of arrest and non-compliance of this requirement would vitiate the arrest of such an arrestee itself. And on that ground, such an arrestee is entitled to get bail. Stop. In this case also, as there has been violation of the fundamental rights of the petitioner guaranteed to him under Article 22(1) of the Constitution of India in not furnishing the grounds of arrest to him in writing as soon as he was arrested, he is entitled to get bail in this case. In view of the discussions made in the foregoing paragraph, the aforesaid above named petitioner is allowed to go on bail of ₹50,000 with one surety of like amount, subject to satisfaction of learned Special Judge Boxer Dhubri with following conditions. Trial conditions. Special Judge Boxer Dhubri. Trial condition. This bail application is accordingly disposed.
Obliged.
Item 43.
Yes.
May I please?
Are you on interim?
Yes, ma'am.
You have complied with?
Yes, on 14/7/25, she appeared before the IO.
Yes, Mr. Sharma.
She has not appeared.
She has not appeared.
Also, I hand over the original certificate copy
Certificate copy regarding,
of the interim bail.
but she has not appeared
No, he handed over.
to the IO.
Not appeared, for the FIR.
I was in order to send it.
Not appeared.
Statement not recorded.
Statement was also recorded.
Statement not recorded. It is a fact. That later on the statement will be recorded and he has been.
Also, the note of the IO, it states, Lordship, wife of accused so-and-so, Kalyani Roy has prepared an application so-and-so. However, till date, she has not appeared before the IO of this case in compliance with the condition of law.
Thing is that, you know, I have handed over the original certificate copy and I also.
How to resolve this issue?
Yes.
Yes, I was told that, Your Honor, my lord, later on statement will be recorded, but till then, no. he
No,
has not-
statement may not be recorded,
Yes,
but you have to appear.
he appeared
You file an affidavit.
on 14/7.
Either you file an affidavit or I am giving you further time to appear again.
For that, Lordship, if I may just submit, Lordship. What has happened, Lordship, in this case, Lordship, the main accused is the husband of the petitioner. That is happened, Lordship. The thing is, Lordship, the husband of the petitioner, Lordship, he is involved in 10 to 12 cases of the same type of cases, Lordship. He takes money from a person, Lordship, showing him a car, and then he absconds, Lordship.
Husband
they-
already granted bail in this case, my lord.
Yes,
Kindly
I'm
pay
just
this page 22, my lord.
Then let him submit.
So that is the allegation against the husband. A number of cases are pending before, against him in different police station of Guwahati, Lordship. Now, Lordship, he was subsequently arrested in Calcutta also, Lordship. Now, Lordship, her allegation is, Lordship, she was abetting him and helping him. And he got interim protection, Lordship, thereafter it was cancelled. And when it was cancelled, Lordship, he absconded, Lordship, along with the wife. And she has not appeared before the IO, that is the statement of the IO, and also there, no, her statement is nothing. It's not.
But I
there.
have appeared on for
No,
14/7.
on oral submission, you have to show something.
Let him
I
file
have,
an
I have
affidavit. Lordship.
You
appeared on.
file an affidavit,
Let him file an affidavit. Lordship.
file an affidavit.
Yes, I'll file an affidavit.
Heard Mr. B. Ahmed. No, what is your
Or,
name?
I may be allowed to appear. my lord.
No.
Lordship, no. He will have to file an
You
affidavit.
first,
My lord, in this case, my lord,
No,
the
he made a
husband already
categorical-
granted
I'm
bail,
sorry,
my lord.
Lordship, for
Kindly pay this
interrupting.
page 22, my lord. Kindly pay.
Lordship, I'm very
This
sorry.
is the
for
order, my
interrupting
lord,
you,
passed
but
by this honorable court, my lord.
He made a
Page
categorical
22, my
statement,
lord.
Lordship, before your Lordship, that the wife.
And
was
wife
already
has no
appeared.
any.
yes, what is your name?
Yes, my lord. This is Dharmeshwar Roy, my lord. Page 22, my lord, annexure 5, my
No,
lord.
Kalyani Roy is the petitioner.
No, order annex.
This is item number.
33.
30.
Heard Mr. T. Hussain, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Learned counsel for the petitioner submits that the petitioner, namely Srimati Kalyani Roy, was granted interim bail by this court by its order dated 10/7/2025, and in pursuant to the directions of this court, she has appeared before the investigating officer
On 15/7.
on 14/7/2025. On the other hand, learned additional public prosecutor has produced the case diary of Kanbajar Police case number 320/2024 and has submitted that there is an endorsement of the investigating officer in the case diary to the effect that the petitioner has not appeared before the investigating officer. The endorsement is of on the endorsement.
12/8/25. 12/8/25.
The endorsement is dated 12/8/2025. In view of this contradictory stand by learned counsel for both the sides, the petitioner is granted one opportunity to submit, to file an affidavit to show that she has complied with the order of this court and has appeared before the investigating officer as was directed. Stop. Let this case be listed again on 8 is okay, or you need more time?
More time.
11th.
I will update the schedule also.
Let the case diary be sent back to be called again after updation.
Leave this.
Item 34.
34 Lordship, the petitioner was granted in interim Lordship. Petitioners were granted interim. They appeared Lordship.
Heard Mr. B. Chaudhary, learned counsel for the petitioners. Also heard Mr. B. Sharma, learned additional public prosecutor. Learned counsel for the petitioners has submitted that all the above named, all the petitioners in this case were granted interim bail by this court on 28/7/2025. And in pursuant to the directions of this court, they have appeared before the investigating officer of Mukalmua PS case number 1667/2025 and have cooperated in the investigation. Stop. On the other hand, learned additional public prosecutor has produced the case diary of Mukalmua PS case number 167/2025 and has submitted that the petitioners have appeared before the investigating officer. Stop. In view of the fact that the petitioners have complied with the directions of this court and have cooperated in the investigation, the interim bail granted to them by this court by order dated 28/7/2025 is hereby made absolute with condition number 1 and 2 attached to the said order remaining intact.
I leave.
Its anticipated bail application is accordingly disposed of.
Obviously.
Here in this case, Lordship, the petitioner is approaching before Lordship after submission of Lordship. He is seeking bail. Here, Lordship may kindly see page 11. Is the FIR.
Also,
No, Lordship. It is 103.
This boy was murdered by this.
oh, school boy.
My son was murdered by him. While
Okay.
coming from the tuition man. Brutally murdered.
Page 11 is the FIR, starts FIR. Lordship will see here 12 persons were named in the FIR. Out of them, all are on bail except the present petitioner, Lordship. And Lordship may now kindly see page 47. This is one of the bail order, Lordship, who was granted bail after submission of charge sheet. So my case was that, Lordship, that I am on similar footing as of page 47. So he may be protected, he will appear before the court.
47 was
face the
granted
person.
anticipatory bail.
Yes, okay, after submission of charge sheet, page 47.
What is your name?
My name is Falu Mullah. Elias Anwar.
My lord, in that case, there was granted, but in this case, my lord, we have to go by the materials, my lord. We have to see the materials, my lord.
Yes.
But that's why
If
Lordship.
materials are different, then he may not get,
My lord, yes.
Lordship may
but
not,
whether materials are there.
My lord, I have to check, my lord. Scan copy, my lord, their materials are there, my lord, but details I have to check, my lord.
No, whether materials are different from the co-accused who has been granted bail. That you have to see,
Yes, my lord. What is his involvement and the co-accused involvement? my dear?
because except him, all others are on bail. And one person was granted anticipatory bail.
Yes, he.
others were granted also, but
Already
they
on-
were granted during investigation. One person granted after charge. And in fact, if your Lordship see page 46,
there was a submission made by the PP that there are two implicating material against two accused persons, not the other accused.
Page-
person. In
page-
every order, your lordship will find against them, there is nothing.
Page
So-
47, that order, my lord, without actually perusing the materials, it was granted, my lord.
Okay, you assist this court, peruse the material. Can you do it now or?
After tomorrow, my lord.
No, so the
Today
case is
also
fixed on
itself I have-
28, next date is on 28, and already NBW was there and lordship has stayed that order.
LBW already stayed, my lord.
Yes. In that case, that has to be continued.
Lord, let him appear, my lord, court, trial court will consider it. If there is anything, you'll get.
No, will.
You
There is-
will, my lord, trial court considers, my lord. It is not the.
It is before the trial court or committal court.
Committal court.
So let it be committed.
Without appearance, how that can be committed?
No, no, last 1 year he is waiting for commitment. Only for him, commitment was not done.
Yes, that is what I am praying. Lordship may protect me. I will appear there, trial will proceed. If I am found guilty, then I will be convicted. That is my case.
Absconding in a murder case, so many days.
And
Now,
yes, case is such a brutal, my lord. A school child was just coming from a tuition. He has been brutally murdered, innocent.
No, what is his role?
role I have to
Okay,
go.
let us give him time.
They have to.
Okay.
Only one thing, Lordship, just, Lordship may point out that in page 46, there is specific submission of the PP that there are implicating material against two persons. And one of them is Zakir. He is granted bail after charge sheet. So I am on similar.
But
that
regarding
must- so he will
Zakir-
verify that aspect and he will submit.
Regarding.
Heard Mr.
regarding
A. Ahmed,
Zakir,
learned counsel
is
for
not
the
discussed.
petitioner, also heard Mr. K. Parashar, learned additional public prosecutor, as well as Mr. S.C. Vishwas, learned counsel for the informant. Stop. Mr. A. Ahmed, learned counsel for the petitioner, has submitted that in this case, petitioner is seeking anticipatory bail after filing of the charge sheet. He submits that all other accused persons are on bail, and one amongst them was granted anticipatory bail after filing of the charge sheet. Learned counsel for the petitioner submits that the petitioner stands on same footing with that of the petitioner. You stand with same footing with Zakir Khan. That of the co-accused Zakir Khan, who was granted bail, anticipatory bail by a coordinate bench of this court on 4/2/2025, and therefore he prays that he may also be allowed to go on anticipatory bail. On the other hand, learned additional public prosecutor has sought for some time to go through the records to verify the role of the petitioner in the alleged offense, in the offense alleged in this case. And also to verify whether the present petitioner stands on same footing with that of other co-accused persons or not. The prayer is allowed. Let this case be listed again on 28/8.
NBW has stayed on.
The interim order granted earlier shall continue till next day.
You're lucky. For amendment allowed, the amended petition has been filed, your lord. Including the informant respondent as respondent number 2, and also added the section 8 of Posto. Notice may go at this stage, your lord.
Heard Mr. JUNM Laskar.
Actually, he is on it. I am
What is your name, Mr. Ghosh?
on behalf of.
What
My
is
name
it?
is not there. He is ill today.
What is your name?
R Majumdar.
Oh, yes. Heard Mr. R. Majumdar, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Issue notice to the respondent number 2 and call for the case diary. The petitioner shall take steps for issuance of notice upon respondent number 2 in pursuant to the prevailing notification of the registry in this regard within 3 days from the date of this order, returnable on 15 September.
I will take step within 2 days.
11 September. List accordingly.
Obliged.
Who orders item 45?
Made please, your lordship. In this case, your lordship, I'm challenging the order dated 25/1/2023, which my vehicle was confiscated. Your lordship may kindly peruse the order. And the.
Why it has come in orders column?
In this case, your lordship, the respondent authorities has not yet filed their affidavit. No affidavit is filed till date, your lordship.
Lordship, pursuant to the order of the learned special judge Pokrachar, Lordship, so a process has been initiated for confiscation of the seized vehicle, Lordship. That is my only instruction. The process has been initiated. That is going on.
May I submit, your lordship?
Yes.
In this case, your lordship, I am the owner of a vehicle. Your lordship may kindly peruse page 56. In this case, the accused was acquitted, your lordship. Page 56, para 18. Para 17, sorry. In view of the discussions made above, I hold that the prosecution has failed to establish its case beyond all reasonable doubt. Consequently, the accused person is acquitted of the offence under section 20C of NDPS Act. Accused person will be set at liberty forthwith, subject to execution of bail bond of ₹20,000 and 1 COT as per section 437A CRPC. As far as the seized vehicle is concerned, section 63 NDPS Act provides that any conveyance used in carrying any narcotic drug or psychotropic substance shall be liable to confiscation unless the owner proves that it was used without his knowledge or connivance. Section 63 of the Act lays down the procedure to be adopted.
Who are you?
I'm the registered owner of the vehicle.
Okay.
I was not an accused in this case.
Okay. Proceed.
Section 63 of the Act lays down the procedure to be adopted in making confiscations and says that the court may an order for confiscation if the article is liable for confiscation, whether the accused is convicted or acquitted and discharged. The proviso to subsection 2 of 63 states that no order of confiscation of an article or thing shall be made until expiry of 1 month from the date of seizure or without hearing any person who may claim right thereto. In the present case, it appears from the record that one Jasbir Singh of district Udham Singh Nagar, Uttarakhand, claiming to be registered owner of the vehicle bearing registered number UK 06CB2253, turn up to seek custody of the same, which pair was rejected by orders dated 7/12/2021 and 2/5/2022 on the ground that he himself stated that he had sold the vehicle to one Sarsited UTP Harjinder Singh, and therefore it is to be understood that he cannot claim any right to the same vehicle. Accordingly, it is hereby ordered that the vehicle bearing registered number be confiscated and appropriated to the state government. Now, this fact, your lordship, it was never sold. It was an agreement. I can show your lordship that it was not sold. The vehicle was not sold.
But you stated before the court that you have sold.
No, your lordship, this fact, your lordship, may kindly peruse. Page 25. This is the agreement, your lordship. Page 26. May I read page 26, paragraph 4, your lordship.
Yes.
That if the second party fails to pay the installment in time, then the first party reserves his right to take his canter back from the second party, and the second party will not get the amount that they have already paid to the first party. So in this case, the first party is the present petitioner, your lordship, Sri Jasbir Singh, and the second party is Sri Harjinder Singh. According to the vote, your lordship. So this was an agreement, your lordship. The
ownership of the vehicle was never transferred. And I was not accused in this case. Now, your lordship may kindly peruse page 32.
It was a sale agreement.
It was an agreement, your lordship, not a sale agreement.
What agreement?
It was an agreement, it was just an agreement, your lordship, between two
Just an
parties.
agreement to
Uh,
do
it-
what?
It is an agreement wherein it was categorically stated that he will pay the money, and once the entire money has been paid, because it was this vehicle was purchased on hire purchase basis, your lordship. So he cannot sell the vehicle. Resin bar. He had taken loan and then he has purchased his vehicle, your lordship. So he cannot sell the vehicle until and unless the loan is paid. So since the loan was not paid, and he was not in a position, your lordship, that is why he has made this particular agreement with the person. If your lordship may kindly see the charge sheet for a moment. Prior to that, your lordship may kindly peruse page 33.
Yes.
Two, your lordship, chassis number MC 283, JRC so and so, engine number so and so, bearing chassis number so and so, and engine number so and so is in the name of Jasbir Singh, son of Deva Singh of house number so and so. So this is the petitioner, your lordship, and he is the owner. These documents were seized along with the vehicle. And this is the seizure list. Your lordship may find the original copy at page 36. And there is a signature of one Paul.
Who has initiated the confiscation proceeding?
It was advised as per the advice of the learned public prosecutor Kokraj, your lordship. It was advised that the state government, that the district magistrate shall have to draw process for confiscation of the his vehicle.
No, whether it has been initiated.
Lordship, as per my instructions, it has been initiated. The process is going on.
You approach before that authority, put up your case before that.
No, your lordship, until
The
and unless,
additional district magistrate Kokraj, your lordship.
until and unless this order stands, your lordship, they will not consider my case because they have made it categorically clear. This order, your lordship, has made categorically clear that I cannot get the vehicle as I have sold the vehicle. That is not the fact, your lordship. I have never sold the vehicle, and this particular document that has been seized clearly states that I am the registered owner
But
of
the
vehicle.
agreement which you were referring to
Yes, your
also
lordship.
clearly state that,
Why I had referred to the agreement, your lordship, because
that is an agreement to sell.
no, your lordship, that is not an agreement to sell in my respectful submission of your lordship.
No, you read page 25, third para.
Yes, your lordship. The equivalent monthly installment will be paid by the second party, henceforth the first party is nowhere liable for the same. However, your lordship, the next paragraph, that is 4. If the second party fails to pay the installment in time, then the first party reserves the right to take his canter back from the second party, and the second party will not get back the amount that they have already paid to the first party. So it was a conditional agreement, your lordship. And I was not aware that this particular gentleman will use it for illegal purpose. In fact, the driver was caught, your lordship, in this case. And he was the accused, not even the person who had purchased, your lordship, Harjinder Singh. The accused, your lordship, at page 38 is Jasbinder Singh, your lordship. He was the driver of the vehicle and he was the only accused. The other person who is named in the agreement, your lordship, who had purchased, that is Harjinder Singh, he was not an accused in the case, your lordship. Now, lordship, for a moment, kindly peruse page the Narcotic Drugs and Psychotropic Substance Act, Your Lordship, paragraph, section 60.
Yes.
3, Your Lordship, subsection 3. Any animal or conveyance used in carrying any narcotic drug or psychotropic substance or controlled substance or any article liable to be confiscation under subsection 1 of subsection 2 shall be liable to confiscation unless the owner or the animal or conveyance proves that it is so used without the knowledge or connivance of the owner himself, his agent, if any, and the person in charge of the animal or conveyance, and that each of them had taken all reasonable precautions against such use. Now, Your Lordship, may kindly peruse page 63. Procedure of making confiscations. In the trial of offences under this act, whether the accused is convicted or acquitted or discharged, the court shall decide whether any article or thing seized under this act is liable to confiscation under section 60 or 61 or section 62. And if it decides that the article is so liable, it may order confiscation accordingly. Where any article or thing seized under this act appears to be liable to confiscation under section 60 or 61 or 62, but the person who committed the offence's connection therein is not known or cannot be found, the court may inquire into and decide such liability and may order confiscation accordingly, provided that no order of confiscation of an article or thing shall be made until the expiry of 1 month from the date of seizure, or without hearing any person who may claim any right thereto, and the evidence, if any, which he produces in respect of his claim. Now, in this case, Your Lordship, before the order was passed by the session judge on 25/1/2023, I was not provided an opportunity. True, Your Lordship, I had filed petition for the custody of the vehicle, Your Lordship. But prior to the confiscation proceeding, at least I should be heard, Your Lordship. This is very clear in section 63. Or without hearing any person who may claim any right thereto.
Where is that order?
That page, it starts from page, page 56 is relevant, Your Lordships. It starts from page 45. Page 56, Your Lordship. एक मिनट रुको।
Yes.
I'm also relying on the judgment of the Honorable Supreme Court, reported in 2024 Supreme SC 909.
What it says.
The Lordship may kindly peruse page 13. The third page, Your Lordship. Para 13. The plain, may I read it, Lordship?
Yes.
I did, Lordship. The plain reading of section 63 indicates that the court cannot order confiscation of an article until the expiry of 1 month from the date of seizure or without hearing any person who may claim any right thereto. It is true that at the same time of the order of confiscation of the dumper, the appellant hearing was not arrested. Had he been put to trial along with the other two accused, probably he would have submitted before the trial court why the confiscation order may not be passed. The fact remains that the appellant is the registered owner of the dumper. In terms of the provisions of section 63 of the NDPS Act, the appellant has a right to be heard by the court before the final order of confiscation is passed and the seizure vehicle is put to auction. In such circumstances, we set aside the order passed by the trial court dated 22 February 2021 in session case number 17 of 2017 to the extent it orders confiscation and auction of the dumper. The trial court shall give an opportunity of hearing to the appellant herein in this regard and thereafter process to pass a fresh order in accordance with law. The appellant shall prefer an appropriate application before the trial court within a period of 6 weeks from today to give an opportunity of hearing so far as the same issue of confiscation of dumper is concerned. Once such an application comes to record, the trial court shall proceed to hear the appellant and pass a fresh order within a period of 2 weeks thereafter. With the aforesaid, the appeal stands disposed of, pending application, if any, stands disposed.
Now, what is your submission?
So, in my respectful submission, Your Lordship, this matter may be disposed of with a direction that at least the court may hear me before the particular vehicle is auctioned, Your Lordship. Because according to me, Your Lordship, section 63 is very clear, which says that I may be heard before an order is passed, which was not done when passing the order dated 25/1/2021, 23, Your Lordship.
Yes. Any objection?
Lordship, that is my only instructions which I have already paid before your lordship. The process is going on for confiscation. And that was done after obtaining the opinion of the learned public prosecutor, lordship.
Heard Mr. T. Deori, learned counsel for the petitioner. Also heard Miss, what is your name? M. Devi.
For the response state, lordship.
This is item number. Learned government advocate appearing for this state respondents. This application is under 226 or 227.
226 and 227, Lordship. There is section 482 of the Code of Criminal Procedure.
This क्या लिखा? This writ petition has been filed by the petitioner, namely Jasveer Singh, impugning the judgment and order dated 25/1/2023, passed in connection with special NDPS case number 10/2021, by which the Court of Learned Special Judge Kokrajhar had directed that the vehicle bearing registration number UK 066B2253, which was seized in connection with the state case, be confiscated and appropriated to the state government. Learned counsel for the petitioner has submitted that the petitioner is the registered owner of the state vehicle, and he had entered into an agreement to sell the said vehicle to whom?
Harjinder Singh, Your Lordship, son of Daulat Singh,
To one
page 25.
Harjinder Singh, son of Daulat Singh, who was the, who is Harjinder? What is his relationship with Jasvinder Singh?
No relation, Your Lordship. It was just an agreement that he will buy the vehicle and he will pay the EMI.
And you are?
I am Jasbir Singh. I'm the owner of the vehicle.
You are also not the accused.
I'm also not the accused. Neither this particular gentleman, Your Lordship, Harjinder Singh, is the driver of the vehicle.
How the vehicle got involved in the case?
Your Lordship, some contrabands were recovered from the vehicle inside the chamber. However, this driver, Your Lordship, who was driving the vehicle, he was subsequently acquitted by this judgment, Your Lordship. Neither Harjinder Singh, neither.
And Harjinder Singh was not made an accused.
No, Your Lordship. Your Lordship, may kindly peruse this charge sheet. At page 38, I have made it very clear, Your Lordship.
On stipulation that he would pay the remaining 53 installment to the finance company at the rate of rupees 36,000 per month. He however submits that the process of sale was not completed and the vehicle was still, and the petitioner is still the registered owner of the said vehicle. He further submits that in connection with NDPS case number 10/2021, the said vehicle was seized as contraband amounting to 52 kgs of suspected ganja was recovered from the said vehicle. Learned counsel for the petitioner has submitted that in the charge sheet, only one accused, namely Jasvinder Singh, who was the driver of the seized vehicle, was charge sheeted, and it is he only who faced the trial. Stop. Learned counsel for the petitioner has submitted that by the impugned judgment dated 25/1/2023, passed in special NDPS case number 10/2021, learned session judge Kokrajhar had acquitted this sole accused person. However, sole accused person, stop. He further submits that though the sole accused person was acquitted by the same judgment in paragraph number 18, learned special judge directed the vehicle, the above mentioned vehicle of the petitioner to be confiscated and appropriated to the state government. Learned counsel for the petitioner has also submitted that the sole ground for directing the confiscation of the said vehicle was that the petitioner petitioner's prayer for seeking custody of the said vehicle was earlier rejected by order dated 7/12/2021 and 5/2/2022 on the ground that he had stated that he sold the vehicle No, you are saying Harjinder Singh was not a,
No, Your Lordship, but the charge sheet is very clear. Harjinder
but
Singh is
order
not-
says that he is charge
Yes, Your
sheeted
Lordship, but it is Jasvinder Singh. Harjinder Singh is not named as an accused, Your Lordship.
to the charge sheeted accused Harjinder Singh. Stop. Learned counsel for the petitioner has further submitted that the order has erroneously mentioned therein that the Harjinder Singh was also charge sheeted, whereas the charge sheet clearly shows that it was laid against only one accused person, namely Jasvinder Singh, who has been acquitted by the impugned order. Learned counsel for the petitioner submits that no opportunity of being heard was granted to the petitioner before directing the confiscation of his vehicle. You have produced the RC?
Because it was already seized, Your Lordship. I had nothing, Your Lordship. All these, that is why the seizure list, Your Lordship. The seizure, everything was seized. The registration certificate, everything. Lordship may kindly peruse page 32, page 36, Your Lordship. This is the seizure list. The registration certificate, everything was seized, Your Lordship. The national permit. Everything was seized, Your Lordship. Page 36 is the original copy, and page 32 I have typed it, 32, 33.
Learned counsel for the petitioner has submitted that the vehicle of the petitioner was used for carrying the contraband without his knowledge. And therefore, same is not liable to be confiscated. Under section 60 within bracket 3 of the NDPS Act. He also submits that as per provisions of section 63 within bracket 2 proviso, as per proviso to subclause 2 of section 63 of the NDPS Act provides that no order of confiscation of an article or a thing can be made without hearing any person who may claim right thereto, and the evidence, if any, which he produces in respect of his claim. Learned counsel for the petitioner submits that the petitioner was not afforded any opportunity of being heard before passing the order of the confiscation, which is in violation of the statutory requirement of section 63 of the NDPS Act. He therefore submits that the impugn order may be set aside and the matter may be remanded back to the learned session judge for hearing on the matter afresh as per the mandate of the law. In support of his submission, learned counsel for the petitioner has cited a ruling of the Apex Court in the case of Pukhraj versus State of Rajasthan, reported in 2024, 0 Supreme SC 909. On the other hand, learned government counsel, government advocate, Ms. M. Devi, has submitted that though you were given opportunity to file affidavit in opposition or not? Though the state respondent have not filed any affidavit in opposition in this case, however, she has the instructions to the, in this case, she has been informed that in the meanwhile, in pursuant to the impugn order, the confiscation proceeding has already been initiated by the competent authority. I have considered the submissions made by learned counsel for both sides and have gone through the materials on record. It appears that the present petitioner was not an accused in the case in which his vehicle was confiscated. It also appears from record that as on date, his name still appears in the registration certificate of the seized vehicle. Stop. Section 63 of NDPS Act provides as follows. Quote, Section 63 of the NDPS Act. The plain reading of Section 63 indicates that the court cannot order confiscation of an article until the expiry of 1 month from the date of seizure, or without hearing any person who may claim any right thereto. Stop. In the instant case, the petitioner's claim was rejected mainly on the ground that on earlier occasions, while seeking custody of the seized vehicle, the prayer for custody was rejected on the ground that he had already sold the vehicle to someone else. However, it is apparent from the record that while making orders of while passing the impugn order for confiscation of the seized vehicle, no opportunity was granted to the petitioner to put forth his case before the trial court. Under such circumstances, it appears that the impugn order has infringed the procedural requirement of Section 63 of the NDPS Act, and same is required to be set aside. For reasons mentioned in the foregoing paragraphs, the impugn order, to the extent it directs confiscation of vehicle bearing registration number UK 06 CB 2253, is hereby set aside. The trial court is directed to give an opportunity of hearing to the petitioner in this regard, and thereafter, after considering his pleas, shall pass a fresh order in accordance with law. The petitioner shall file an appropriate application before the trial court in this regard within a period of
2 weeks.
2 weeks from the date of this order, to give him opportunity of being heard so far as the issue of confiscation of the aforementioned vehicle is concerned. Once such an application comes on record, the trial court shall proceed to hear the applicant and pass a fresh order within a period of, no, not within a period, pass fresh order as expeditiously as possible thereafter. With above observation, this writ petition is hereby disposed of.
I'm very grateful, Your Lordship. 445, two matters are there. Item number 43 and 44, my lord. In these two appeal, one appeal, I was aggrieved by an order passed by the learned court. whereby I was convicted under, it was initially charged was same under 325 and 331,
43 and,
43 and 44.
okay.
So now in 44, they are for the complainant. So what the original complainant has died in an accident. So now they want to file a substitution. The wife has come. So today only it has been let me go through it. The substitution application which they have filed. And let it come on on another date. On 9th, if it is not incoming, 9th.
43 and 44.
Yes.
Due to paucity of time, this matter could not be taken up today. Let this matter be listed on 9th,
9th, it is it?
9th of September.
As regard item number 39, 39, matter may kindly be taken up day after tomorrow, for modification of condition of plans. As day your lordship may kindly take up.
All leftover matters, you have to pray before registry.
Look, supplementary item 49, it's a conviction of 1 year, my lord. So may I pray for tomorrow, my lord, admission, my lord, because otherwise that was for only 30 days time was given, my lord. That's expiring
39,
49, supplementary 49.
when that 30 days would left.
Because it already expired on 18, my lord. We have submitted before the lower court that the appeal is filed, is likely to be listed, my lord. So it's there on Friday.
Friday, next date is Friday, your lordship. Tomorrow,
Okay, tomorrow.
Lordship, my lord,
Allah bless.
production list, my lord, item number 3, my lord. In the morning, we had made a mention because of the urgency, my lord. It may be listed tomorrow, my lord.
What is the matter?
Matter is a criminal appeal, my lord. We are praying for a suspension of the sentence because the time is going to expire, has already expired.
You are on bail.
Yes, my lord.
You are on bail.
Yes. But there is an urgency, my lord, because
When it will expire?
it has already expired, my lord, because there was some, the certain correction had to be made with the date, certified copy we had to again obtain
Okay, tomorrow.
tomorrow.
Lordship, tomorrow we have one item 10. Can today's item 36 be taken up with that, the same matter?
No. Yes, Mr. Sonar.
I don't have any objection. If it can be taken up, Lordship, it will be highly.
You are in this case for cancellation of bail.
Lordship.
What is item 10?
Item 10 is the cognizance order whereby the trial.
Okay, tomorrow. Item number?
10.
Now today's item number?
36, 37, 38. Lordship.
36, 37, 38. On request of learned, on request of both the parties, this matter be listed tomorrow along with item number 10,
10. Criminal petition 5.
along with criminal petition number
558 of 20.
558
8 of 24.
of 2020.
My lord, I'm sorry to disturb, my lord. My lord, item number 45, my lord, hearing matter, my lord. Your lordship remembers on the last occasion, your lordship has fixed it today for hearing. It's a small matter. I am for the respondent, my lord. The petitioner has filed this present provision petition on the ground that he seeks an enhancement of the compensation amount. So, my lord, regarding that issue only, my lord, the matter is there.
Item number?
45, my lord.
Now what is your submission now?
No, my lord, since he is also here, and it be
noted.
fixed on a date, my lord. The lordship can decide this matter. my lord.
Choose a date.
On 4th of September, my lord.
Fifth maybe lordship.
As per board.
4th is the hearing day.
12th of September.
10th of September.
12th.
12th September. I'm deeply obliged.
12th September is holiday maybe.
Can it be on 11?
11.
11 September.
I'm deeply.
Highly obliged.
Item 41, but I missed the papers, so I may be allowed to print the papers, there is the evidence part. I have got the appeal part, but I file I could not trace. So I made a mention.
You are legal aid counsel.
No, I'm the counsel, not the legal counsel.
Then you can pray for certified copies also.
There is lower court part, court part. There is the witnesses, the evidence part. I think, if an order is there, then it will be sufficient, but otherwise the lower court, whether it will be granted to me.
You show me the provision, I will allow you. Till then you
Well,
can,
my
you-
problem is that,
unless you
I
show
would-
me the provision, you show me the provision, I will allow you.
the matter, is, the lesser matter, maybe after 20th, if listed.
No,
that might-
the registry will give the date.
Ah.
It will be shown as leftover. And registry